computer's being slow. All right, this is 23 CF 475 State versus Josie Dikeman appearances.
Matthew Tarbinson and Emily Rood appear for the state. Also present at State's counsel table is Investigative Sergeant Rich Amundsen. Good morning.
Morning, Your Honor. Ms. Dikeman appears in person with her attorneys Chris Zachar and David Bowles. Also present is paralegal Emily Sanchez.
Okay. So a couple things. What I was doing right now is I was looking at the emails that were sent last night. They were forwarded to me by Ms. Langer. Just so you know, I realized after we were done yesterday, there was two different instructions we had not put in. One was the falsus new. The other one was hypotheticals. We never put the hypothetical one. It's pretty short. I also knew that there was an issue on the falsus new instruction, knowing that's disfavored. I knew that from the instructions, looking at the history of it. There is a lot of contradictory information that's out there for a lot of different witnesses. If I do have it in there right now. We can discuss it more later. I just put it in there just as at the end of the witness section. I agree with Mr. Torbenson. Generally, it should be neutral. It should be just general. It shouldn't be specific for the children. I know I said something about the children, but I think what I was thinking is that it would be put in there generally. I'll give you an opportunity to respond to that, Mr. Zachar. I'm just wanted to let you know that's where it's. So I did put those two in. I know that we've done the verdicts, and we've done the redid the whole verdict section at the very end of the jury instructions, so we have that. We're not actually done, so we can do one more jury instruction conference to go after the details. Plus, I see the additional information for Mr. Pedrin for 275, and I don't know if that was just a couple minutes ago. I don't know if you had even a chance to look at it, to be honest.
And I also filed amended information. Incorporate the language that we talked about yesterday.
Yeah, that. Let me look to see if has been crossed over yet. Maybe it was. Yeah, and I see there's a. What? It's sitting out there. Okay, we'll cross that over. We'll take a look at that. And the state had said that you will have at least maybe 2 witnesses on rebuttal now?
I believe it'll just be one at this point, Your Honor.
Just one? Okay. Any issues other than what I just talked about, which we'll talk about again after your witness is done?
I don't believe so.
Mr. Zachar?
Beyond what we have to discuss on the falsus and nuno and the amended information.
Okay.
I agree that the hypothetical standard instruction.
Yeah, did you have a problem with the hypothetical? We just didn't mention it last night.
It was done a number of times, so I think it's appropriate.
Okay. All right. Having said that, actually, I don't even know if the jury's up. We have a few minutes before they come in.
Want to make not guilty pleas on the new information, Judge?
Yeah, it's crossed over now. Okay, yeah, why don't we do that? Hold on one second. All it did was change the language, correct?
On count two, it just,
Yeah.
yes.
Yeah. Everything's a little slow this morning. Do you have a copy of the information, the amended information?
I got an electronic copy by email this morning.
Okay. Ms. Dikeman, in count two now, in the amended information, this might be the second amended information, it charges, same charge, chronic neglect of a child, consequence death, that between January 1st, 2021 and February 11th, 23, that the same time, the only difference is that it changed the language to that says did negligently fail to provide necessary care, necessary food, necessary medical care, necessary education compliance under 118.15 and exposure to drug abuse is defined by 46.973 parent 1 parent D, and then the rest is the same. Do you need me to read more than that?
No, Your Honor, we'll acknowledge receipt of the amended or the Second Amendment information, waive its formal reading. We are specifically objecting, as we did before, to Ms. Dikeman's constitutional right to notice and present a defense with the second subsequent amendment. Those objections notwithstanding, Ms. Dikeman will enter a plea of not guilty.
You enter not guilty plea to that amended count. The not guilty is already entered in for count one and count three. Also, the court made a decision allowing the state to amend it as of yesterday. So that does remind me, I did modify those instructions on count two with the language for 118.15 and 46.973 parent 1 parent B. I just took, there is actually a jury instruction for 118.15, then I had to take the statutory language for that 46.973 parent 1 parent B. But we'll get you copies of that. I'll have Christina send what current copy we have. Remember, this is still a rough draft. It's not the final draft, but.
You want to hear my response on falsus in uno now, or do you want to do that?
Sure. Why don't we have a little time. We still don't, if you want to talk about falsus in uno, go ahead.
I absolutely agree with the court and Mr. Corbinson that falsus in uno is a disfavored instruction for a number of reasons. This is only the second time in my career I've ever asked for this, the first time being when I was a law student doing clinicals. I think it's appropriate specifically to at least the one witness to acknowledge that he had been dishonest under oath previously. My problem with making it general is that it, or at least not carving out an exception for the defendant, is that it impacts the presumption of innocence. If the jury's instructed that they can just disregard her testimony entirely at that point. So if we're giving a general instruction, I would just like a caveat added onto there that this doesn't apply to Ms. Dikeman.
I think that's why it's disfavored, actually,
Yeah.
for exactly that reason. And it's one of those questions yeah, I mean, that's why it's disfavored.
Judge,
Yeah,
my response is actually that it shouldn't be given at all. There's two cases. There's the Wisconsin Supreme Court case, it's State versus Plude, that is found at 2008 WI 58, and it's discussed at paragraph 71. that case was overturned on other grounds related to another issue, not on that specific issue. And it's State versus Lagar, Lagar, which is found at 190 West 2nd, 423, Wisconsin Court of Appeals decision. Both of those cases discuss at length why the instruction is disfavored, and it's in essence, it's because the credibility instruction tells the jury how they're to weigh credibility with regards to all the witnesses, and certainly a witness giving contradictory information goes to that witness's credibility. My problem with the instruction is a witness can get up and say something that one party may interpret as material, the other party may not interpret as material, and they're going to argue that all of his testimony should be discounted because of that one thing that he said, whereas there may be motives and reasons to explain why he did what he did, and he came in and subsequently corrected that when he testified. So I'm asking the court not to give the instruction. I think the credibility instruction adequately covers all the factors that the jury is to consider with regards to all the witnesses, the defendant, and every single other witness that took the stand in this case.
Your Honor, the problem with that is that we'll be left without a remedy for the situation that we got into with Brantley in particular. So our request is that it, at the very least, be given specific to Brantley.
The only other thing I'd point out is some of the case law where it discusses it. It's where the prosecution asked for it relative to a defendant's testimony. So that's the other reason why it appears as though the prosecution may be able to ask for it relative to the defendant. I am not in this case. I want the general credibility instruction for Ms. Dikeman, and I want that for every other witness as well.
Yeah, one thing that it says in the logger is that impeachment of a witness with prior statements does not necessarily mean in falsus in uno instructions appropriate. The testimony must show a willful and an intentional disregard of the truth. The trial court has the best position to make the call. We see no error in the court's discretion. It's obviously jury instructions are left to the court's discretion, which is part of why they didn't strike it down on that basis. But what I find interesting, the question is, you know, is it a willful and an intentional lie? I think the argument has been that it's been influenced from the defense, correct?
That the testimony was coached and influenced, yes, but I mean, I think all we needed was when he came back on the stand after the break and acknowledged that he had lied under oath. That seems to fit the definition of willful intentional.
Yeah, it's a kid though. I mean, this gets more complicated because it's a kid. I mean, I think that's where it gets. I mean, there are a lot of issues with children testifying, and it becomes very complicated because even getting to the truth and lie, where there was sort of you know, there are hesitations in the original about if they understood fully what it meant, of course, with the explanations, red, blue, markers, etc. Those are easy things to say yes and no to. Do you understand the consequences? And there was sort of a blank no response to it at different times. I mean, that's all part of closing argument to a degree. I mean, about the reliability of those statements. The question is falsus nunu, is that really appropriate given that situation? We're going to have one more meeting. Give me a little more time to think about it. But I understand the state's position. I understand what the case law says. I read the other case before. I hadn't read this case. the question really in my mind is, are you getting to a willful, intentional lie, or is this part of this, the theory of the case is, the theory of at least the statement by the child is that it was somehow influenced, not to mention the ability to essentially manipulate memories. We know that happens with children. There's famous cases over that, probably one of the most famous from Minnesota. So it becomes one of these issues of, what's the real intent of the child, or is it the manipulation of the child, or sometimes for children, it's also not even a manipulation. It's just it was testified to that Brantley, for example, has a very active imagination. So I'm not sure. I just thought out loud and said it out loud. And so give me a moment to think about it. And we'll talk again.
Can I just add one thing on that last part?
Yeah.
So when he came back and took the stand, I think it's important to note that when he went outside, his father was upset with him, not coaching him. He was upset because he was denying that there was domestic abuse. And then he came back in and said exactly that he had an encounter with his dad. And so the testimony establishes, he also said he was trying to protect his dad. He thought somehow, I think there was questioning by Attorney Zachar, that he believed that if he said something relative to his dad abusing Miss Dikeman, that may cause his dad to get in trouble. That's not an intent to get Miss Dikeman in trouble. That's an intent to protect his dad, which is very different, at least in my mind. I think that all of that can be argued in credibility. I don't think we need the falsus in uno to address it.
The other issue just generally is I don't want it to create the constitutional issue, which is, as you were saying, the constitutional issue, which is all of a sudden, I know this is why you want the specific, language in it, Mr. Zachar, but the reality is that I'm not sure. So it says, okay, in this one witness, it also would highlight this one witness. I mean, it's not necessarily, that's not necessarily the purpose of it. I've seen attorneys argue the rotten piece of meat in the stew, analogy many times. Do you eat the whole bowl of stew, or do you eat the rest of the stew, or do you throw it all out because one piece is rotten? So
I'm more of a sandwich guy, Judge. But
the sandwich guy, yeah. I think it's a Belzer one.
Yeah, my just correcting the record on the point. I believe what the child came back and testified to was that he was lying about his father drinking, not about the violence.
Okay, so I'm going to hold off a little bit. I'll be frank. I'm leaning towards taking it out right now altogether, and just letting you argue it.
Sure.
But let's give it another moment. Plus, we have to work on the language on the 275.
Judge, I just sent our counter proposal on 275, and we can talk about that later, since I know no one's had time to review it.
Yeah, let's talk about that later. You sent that to Christina, right?
Yes.
All right, so she'll forward it to me eventually. Let me go see what's going on with the jury. Oh, okay, somebody's running late. Why don't we take about a 5-minute break, and we'll start once they're maybe seated.
Objection to the revised 275.
Okay, so you're, okay. I heard that. Okay. Everybody's back in the courtroom. The jury is all here now. Can we bring the jury in?
Yes.
Before, one thing, I will say to the jury that defense rests. Now it's an opportunity for rebuttal, just to explain where we're at, and then I'll have you call your witness. Okay, let's bring the jury in. Everybody may be seated. Morning, everyone. We will, at this point, I think when you left yesterday, we had, the defense had rested. At this point, the state has the opportunity for rebuttal. We had to wait a little bit till this morning. What we'll do is we'll start with the state's rebuttal, if you want to call your first witness.
Thank you, Your Honor. State calls Investigative Sergeant Rich Amundson.
Do you solemnly swear the testimony you give in this matter shall be the truth, the whole truth, and nothing but the truth?
Thank you.
Good morning.
Morning.
Can I have you state and spell your name again for the record?
Richard Amundson, A-M-U-N-D-S-E-N.
And Sergeant, I'm going to hand you another stack of documents, and we'll go through them one by one, okay?
Okay.
Sergeant, do you recall during Ms. Dikeman's testimony yesterday that the bag of pills that we've been discussing in this matter may have been placed on or on top of her clothes hanger?
Yes.
And when you were processing the scene, did you have the opportunity to observe the clothes hanger in her bedroom?
Yes.
If I can have you look at Exhibit 154, Sergeant, can you please identify what we're looking at here?
This is a photo from Miss Dikeman's bedroom showing the clothes hanger rack storage shelf.
And from your review of that photo, is it in the same location as it was when you processed the scene on the 11th of February, 2023?
Yes.
Is it a true and accurate representation in that photo?
Yes.
Your Honor, I'd move for the admission of Exhibit 154 and request to publish, please.
Okay.
No objection.
You received? Go ahead. Publish.
Let's switch to my computer, please. Sergeant, can you tell us what we're looking at here?
To orientate yourself, these are the French doors that go into the living room. Miss Dikeman's bed would be right in here. And then in this corner is that clothes rack with hangers here and here, and an area to store things above it.
Thank you. I'm going to have you look now at Exhibit 155. And before we go through this, do you also recall over the last few days there being testimony about the pictures Ms. Dikeman was taking around 9 p.m. on the evening of February 10th?
Yes.
And was there discussion of whether or not Ms. Dikeman had makeup on in those photos or was using a filter or things along those lines?
Yes.
I can have you now look at Exhibit 155. Is this another Cellbrite extraction report from Ms. Dikeman's iPhone extracted on the 13th of February, 2023?
It is.
And is this specific report related to the photos Ms. Dikeman captured between 9 p.m. and approximately 9:30 p.m. on the 10th of February?
Yes.
Given your review of this data, is it a true and accurate reflection of what was on the Cellbrite extraction for Ms. Dikeman's phone?
It is.
And Your Honor, I'd move for the admission of Exhibit 155.
No objection.
Received.
Sergeant, does this extraction report identify that there were 41 files contained in this portion of the extraction?
It does.
And from your review of this report and the data, does it appear that the phone is capturing both the full-size image and also a thumbnail image when we're pulling the information in this report?
It does.
So when we're looking at the overall total of photos actually captured, does it appear that there are about 20 photos of Ms. Dikeman captured in this time period?
That is correct.
If we look at entry number 1 in this report, Sergeant, can you please tell us what the capture time is for that first photo?
February 10th, 2023 at 9:02 and 42 seconds p.m.
And then if we look at number 39 on page 10 of this report, what time does it indicate that that selfie or photo was captured?
February 10th, 2023 at 9:20 and 14 seconds p.m.
And then if I can have the Elmo, please, I'm going to republish Exhibit 254. Sergeant, is this the photo that was testified to as being sent to Mr. Suarez by Ms. Dikeman on the night of the 10th of February?
Yes.
And if we look at entry number 18 on Exhibit 155, does it indicate that the file name related to this image is IMG_0549 period HEIC?
Yes.
And what is the capture time of that image?
February 10th, 2023 at 9:16 and 31 seconds p.m.
I can have you now turn to Exhibit 156 in front of you. Do you recognize this exhibit?
Yes.
Is this one of the selfies captured by Ms. Dikeman during the period of time we're talking about right now?
Yes.
And if you can, while we're identifying this, refer to report 150 or Exhibit 155, Sergeant. Does this photo have the file name IMG_0541 period HEIC?
Yes, it does.
And what is the capture time related to that image?
February 10th, 2023 at 9:02 and 42 seconds p.m.
And is this information, including the contents of the photo, true and accurate based on your review?
Yes.
Your Honor, remove the admission of 156, not requesting to publish quite yet, though.
No objection.
Received.
If I can have you then turn to Exhibit 157, Sergeant. What are we looking at here?
This is another selfie that Ms. Dikeman captured on February 10th of 2023. This time she's wearing glasses and makeup.
And if you refer to Exhibit 155, specifically entry 38. Does this particular photo have a file name of img0559.heic?
Yes, it does.
And what's the specific capture time related to that photo?
February 10th, 2023 at 9:19 and 12 seconds p.m.
And based on your review of the information, is the content of the photo and that creation data we just discussed true and accurate?
Yes.
Your Honor, I'd also move for the admission of Exhibit 157, not requesting to publish quite yet.
Objection.
Be received.
Now on to Exhibit 158, Sergeant. Can you please explain to us what you're looking at here?
Exhibit 158 is the two photos I just discussed side by side on the same sheet of paper.
And is the information contained, including the content of the pictures and that file name and capture time, true and accurate based on your review?
Yes.
Your Honor, I'd move for the admission of Exhibit 158 and request to publish.
Objection.
Receive, publish.
Have it switch to the computer, please. Okay, Sergeant. So these are the two photos, 156, which was captured at 9:02 p.m., and then 157, which was captured at 9:19 p.m., correct?
Correct.
Okay. And what facial features, based on your observation, do you see differently in these two photos?
To start with the one captured at 9:02, you can see how Ms. Dikeman's hair isn't brushed out, more stringy. You'll see that there's no eyeliner between the first photo to the second folder. It appears her skin tone is more leveled out. Then she's also got lip gloss on in the second photo compared to the first photo. You can see here that Ms. Dikeman's hair has been brushed out and is on now the left side of her body compared to more on the right side on the first photo.
And that second photo's capture time is 9:19 p.m., correct?
Correct. And the most obvious is obviously she's got glasses on compared to no glasses.
Thank you. And that 9:19 capture time is about 3 minutes different from the capture time of approximately 9:16 that we saw in Exhibit 254, the photo with Ms. Dikeman and Brantley, correct?
Yes.
Thank you. I have nothing further.
Okay. Redirect, or recross, I mean, or cross,
Simeon.
excuse me.
Yeah. All right. So, Sergeant, I want to look at 154 again. My copy of the state's exhibit. It looks like there's a flexible fabric shelf system in that photo. Is that correct?
I'm not sure, but
I have one of these in my closet, so I know what this looks like. Let me zoom in on it. Kind of looks like it's kind of hanging, and the shelves are sagging a little bit.
yes.
The only empty shelf on this unit would be the bottom one. I can zoom out if you'd like to see the top.
Yes.
Don't see any hangers that were apparently knocked over from taking a bag off of the top there.
No.
Let's talk about the pictures. Sergeant, would you agree with me that everybody takes pictures, that they don't necessarily like or say, I'm going to delete this one of myself.
Sure.
And Ms. Dikeman, in some of those earlier pictures, would you say looked a little bit haggard?
Yes.
Like maybe she hadn't been feeling well?
I don't know how she was feeling.
And the photos that she was sending to Mr. Porfirio were the touched-up versions. Is that fair to say?
I don't see anything where a filter was used to touch him up. I think her face was touched up.
Yep, that's what I meant.
Oh, okay, yes.
Where presumably if Ms. Dikeman's trying to impress her date, she's going to take the picture where she looks good and send it to him.
I would assume so.
And just looking at some of the photos here, I'm going to bring 158 up to you because I'm not sure the glare really.
He has it in front of him.
Oh, sure. Would you agree with me, Sergeant, that some of the same facial blemishes appear on both photos?
Yes.
In other words, she has a cold sore or something above her lip.
I don't think it's a cold sore. It looks like a freckle or something.
Same thing on her cheek there. Looks like there's either a freckle or something else.
Yes.
Okay. I was not a makeup expert until yesterday, but does it look to you that she applied foundation?
I'm not a makeup expert either.
Okay. And just looking at the earlier photo here, Sergeant, the 156, we can actually see that Ms. Dikeman does appear to have eyeliner on, just maybe not applied as consistently. Can you see that?
I can see her bottom eyelashes, but it doesn't appear that there's any eyeliner on there compared to 157.
Sure. I'll just walk up to you for 156 here. And again, I'm not sure the glare will capture this on the Elmo, but do you see eyeliner or what appears to be eyeliner on the bottom of Ms. Dikeman's eyelids?
I see black individual eyelashes.
I'm going to try and publish 156. It's glossy, but we'll see. And I'm going to zoom in on her eyes. Can you see the shade underneath? I guess that would be her right eye.
Yes.
You see the shade under portion of what would be her left eye?
I can see what you're pointing out, yes.
And does it appear that there is, I knew the word for this yesterday, but the makeup that you put on top of your eye lids?
I don't know.
Mascara?
Honor, I'm going to object to this. I don't think he has a frame of reference for what her eyes look like with or without makeup based on this photo. And
Yeah, he's saying he doesn't know makeup,
Okay,
so
yeah.
I'll sustain the objection.
It's apparent to you that Ms. Dikeman was trying to make herself look cute to send a picture to Raphael?
asked and answered, Your Honor.
Yeah, sustain.
All questions I have.
All right, any redirect?
Very briefly, Your Honor. Investigator, was the testimony we heard from Ms. Dikeman that the bag would have been placed up high out of the reach of children yesterday?
Yes.
And is there a flat surface on top of that clothes hanger?
Yes, on top of that clothes hanger, there is a flat surface and there's other items on top of it as well.
Thank you. Nothing further.
Any requests?
Sergeant, do you still agree that there's no way to determine whether or not that bag was actually there on February 10th on top of the shelf?
I do not know that.
Nothing further.
Anything further?
Not on that, Judge. Thank you.
All right, you step down when I handle the exhibits. Any other witnesses from the state?
No, Your Honor, state rests.
Okay. So with that, ladies and gentlemen, that ends the testimony evidence for the trial. We did some work yesterday, so we do need a little time to finish up what we were working on. They're the jury instructions, which I'll be giving to you next, and then we'll be going to closings. What I still ask you to do is please don't talk about the case. I know we're done with the evidence, but until I give you the instructions, I can't have you talk about the case. And then once we do the closings, 2 random numbers will be picked, and 2 of you will be the alternates. I really do appreciate all 14. You made it through all the whole time, but we do need to get down to 12 people at that point. Having said that, we will see you. Every time I predict this, I predict wrong, but it will at least be about half an hour to 45 minutes. It could be a little bit longer. Okay, thank you. Everybody may be seated. Give me 1 minute to incorporate what you just sent me, and then we'll print this off, have you look at it. We'll take about 5-10 minute break, and then we'll get together and talk. Just so you know, I did highlight 305 just because to remember that we need to talk about it and finish our discussion. But I'll incorporate, actually I'm going to have Christina. And just so, this was not on the record. There was Ms. Rude sent a proposed addition to 275, and I happen to overhear that there was no objection to it. Is that correct, Mr. Zachar?
The 275 as to Mr. Pedrin, yes.
Right, the part, and I was going to add that before the propensity language.
Sure, yeah, I agree. The state's version's cleaner.
Is that agreeable with the state?
It is, Your Honor. I think the indication was that it was okay to use the definitions of the pattern instruction. The only thing I indicated is that there's not a pattern definition for source of injuries. That one might be more self-defined anyway. The other ones, right, are more legal terms. But that was the only unknown there.
All right. So it's adding that and then the definitions of, I believe it was.
Yeah, the bracketed definitions in 275.
Right. All right, that will take me a moment to do that. I'm not going to do that right here. But what do you, source of injury question? It's almost.
I think it's self-explanatory.
Okay. All right. Well, we'll use the other definitions then. Anything else I should put in in the jury instructions? Other than is there anything else?
To my knowledge, they're complete. We'll eagerly await our copies from Christina.
Yeah. And the state's okay so far, trying to incorporate that. Then the last issue are the verdicts. We are putting those together. One thing I did on count 3, which is normally we just say guilty, not guilty, then go to this question. I did put in that language that they must agree on about the event for either causing death or for great bodily harm underneath it. You'll take a look at it, and we can change that if you want the order to be a little bit like that sentence before the sentence or after. But I did add that. That doesn't necessarily, I'm not sure I don't know if there is a standard verdict on this, to be honest.
I'm not sure there is, but I think that language is really important because they do have to be unanimous as to that fact.
Right.
I would agree with the unanimity language.
Yeah, I don't want to run into a unanimity issue by not having it there. So, okay, I'll. be seated? You can be seated. Did I bring, oh yeah, I did bring that in. We didn't print out the verdicts yet. Just realized that. There should be a cup. I'm gonna go check something quick. I'll be right back. I'll come to the side. You don't have to do all the rest. Okay. Everybody ready?
Yes, Your Honor.
Okay. Stay ready.
Yes, Judge.
All right. Let's go through the instructions. We'll deal with the verdict. I already see there's some problems with the verdict, but we'll deal with that second. Okay. Page 1, standard. Page 115, or page 2, which is 115. Any corrections to page 1, 2, 3, 4, and goes for a while, 5, 6. Any corrections from the state's perspective on 115?
No, Judge.
State or defense?
No, Your Honor.
Okay. So that takes us to page
Oh, Judge, I was specifically referring to count 1. We do have a minor change in count 2 on page 9.
Yeah, I was just getting there.
Okay.
No, I'm just talking about count 1. Now we're in count 2. I'm sorry. I meant count 1. Now we're in counting chronic neglect of a child consequence. Where's the, what needs to be changed?
On page 19,
9 or?
excuse me, yes, 9, thank you. It should be action or failure to take action. which is what the language is on page 10 when the elements are described.
Can you just say what?
Yes, so Josie Dikeman, reading the charging language there, being a person responsible for the welfare of a child through her action, and then it should be, or failure to take action for reasons other than poverty. That language is already on page 10. Just
Right. Yeah. Do you agree with that, Mr. Zachar?
I think that's what the court ordered yesterday.
One more moment. Why did it do that? Sorry, it's all of a sudden I did that and all the spacing got strange. What the hell? Okay. All right. Anything else in count two?
no, Your Honor.
Anything from the defense? All right. Hearing none, we'll go on next to.
I'm still scanning, but I.
Oh, okay. Go ahead. Sorry.
All right, yeah, we can go to nothing else.
Okay. Hold on one second. Do not know why is that happening. Right. All right, going on to count three, which is on page 13. Any from the state? Any changes?
No, Judge.
Same, with the same unanimity objection that I made previously, no objection.
Okay. And then 140 is standard. We did make that change to reasonable hypothesis yesterday. Spacing is all funny now. Hold on one second. Anything on 140?
No, Your Honor.
No.
So then we get to 145 and 103. Any corrections to that?
No, Your Honor.
No, Your Honor.
170, 155. Any corrections?
No, Your Honor.
No, Your Honor.
So here's 275 with the modification that we've added. I just put evidence presented for Josie Dikeman, evidence presented for Derek Pedrin as a way to distinguish the two as headers. That's one addition, plus I added obviously the definitions below.
Judge, I think there are some changes in the definitions for Mr. Pedrin, because obviously the pattern instruction is designed for defendant.
Oh,
So
yeah.
we need to change defendant in there, or the defendant to Mr. Pedrin, and then I think probably change offense charge to conduct alleged
Yeah.
for each of those.
Yeah, it was quickly done.
No objection to that.
Obviously, that needs to be done. To conduct alleged.
I think that fits best.
Any objections to that?
Judge, I was distracted by the noise outside. Which section?
So we're still on definitions of Derek Pedrin. So it says right now, opportunity, that is, whether Mr. Pedrin had the opportunity
Yeah, no objection.
to
Objection to swapping.
commit to,
I think just relating to the conduct alleged.
so it'd say whether Mr. Pedrin had the opportunity relating to the conduct alleged.
I would say like whether he had the opportunity at the conduct alleged.
Yeah, I think if we just change offense charge to conduct alleged for each of them.
I need one more word in there, though. That's the problem.
For each
To
of them,
commit conduct alleged.
commit the conduct.
The conduct
Alleged.
alleged, yep. Intent, whether Mr. Pedrin. Okay, so this is how that paragraph will read. Definitions for Derek Pedrin. The evidence was received on the issue of motive, that is, whether to, excuse me, I know I missed one. That's why I read it out loud. Whether Mr. Pedrin has a reason to desire the result of the conduct alleged. Opportunity, that is, whether Mr. Pedrin had the opportunity to commit the conduct alleged. Intent, that is, whether Mr. Pedrin acted with the state of mind that is required for the conduct alleged. Identity, that is, whether the prior conduct of Mr. Pedrin is so similar to the offense, the conduct alleged. That it tends to identify the defendant as the one who committed the conduct alleged. Context.
Yeah, we're.
The defendant, thank you. I find that Mr. Pedrin. As the one who committed the conduct. So it says, let me go back. Identity, that is, whether the prior conduct of Mr. Pedrin is so similar to the conduct alleged that it tends to identify Mr. Pedrin as the one who committed the conduct alleged. And then finally, context or background, that is to provide a more complete presentation of the evidence relating to the conduct alleged.
Good.
All right.
I think we have the same issue, or slightly different issue in the propensity-free reasoning part.
Yeah.
Because that's still just relating to Ms. Dikeman.
Just hold on one second.
Judge, I think we could just change that to because a person committed another act or crime, they probably acted the same way again.
Mr. Zachar?
Judge, this is another one of those scenarios where the constitutional rights belong to Ms. Dikeman, not to Mr. Pedrin. I think the language is appropriate.
Even with character, though, Your Honor, you can't argue propensity.
I'm going to leave that as, because the issue you run into with the propensity-free reasoning is really paramount on the issue of the defendant. There are other issues that come in. It's, as seen, 275 was originally designed to be for defendants. That's why we ran into the issue. I'm just going to leave that as is. Yeah, I mean, the propensity-free, it's explaining an example anyway. That's what it really is doing. And then the very last phrase needs to be there because that's correct, about Ms. Dikeman.
Sounds good.
Yeah, all right. So 157?
Objection.
No objection.
148, 147, 150?
Looks good.
No objection.
Hold on one second. 158, 190.
Standard instructions, no objection.
Yeah. I did have to modify 158. Is that okay?
Yes.
Yeah, it's fine. It's modified.
Okay. 190, 195, and then 195, 200, and then 205.
Good.
All standard, no objection.
300, standard,
No objection.
No objection.
325, 327. We change those.
And
No objection.
340.
No objection.
no objection.
And then I made the decision not to include 305 in the end. I decided that it's, there's too many issues that come up with it. It's not recommended. You can make arguments, obviously, during closing. And then back to this 160, 465, and 484. Let's do 160, 465 first. Any problems with that?
No objection.
Okay, 484. I'm just wondering. I think in night, I was going to add, so this gets to the verdict question. What I was going to add at the bottom of maybe before the dated line on, so if we're looking at count one, verdict, page 1, that I would add if you find Josie Dikeman not guilty of count of first-degree intentional homicide, go to page 2, and then, or go ahead, or do you have better language?
Because the way I usually see it done is that it says first-degree intentional homicide, and it just says guilty. Then there would be a second one for first-degree reckless homicide that says guilty. Then there would be a third form for second-degree reckless homicide that would say guilty. And then there's a fourth independent verdict form that says, we, the jury, find the defendant not guilty as to count 1.
Yeah, that's how we did it in a number of other cases. That would be my preference as well.
Okay, all right. So we'll, I have to admit, I don't have very, very often, especially this one. So you would just have everyone listed? Do you need to have a line that if you find them not guilty, just,
Because they're not necessarily finding not guilty, they're just saying they can't agree, so then they're moving on to the next one to consider that one. That's how the instruction tells them. It says if they can't agree on the higher count, then they move on to the next one. Not that they're making a finding of not guilty on those higher counts.
should that line be in there? If you cannot agree on
If
this
you
first
wanted,
count?
I think you could add a line as to each one. If you cannot unanimously agree as to first-degree intentional homicide, you must consider the next lesser included offense. But it's up to your honor. Otherwise, I think we'd be fine just having a guilty for all the three, then having a not guilty as to count one is the fourth.
If the court still has the instructions from the Mitrell Anderson case, that was the language we used.
Well, that might be helpful. Hold on a second. Wow, that's a long time ago. I'm not sure I have that. All right. So assuming we change that, that's in count one. Count two, any problem with the language in count two? And, oh, by the way, what I would do is 44 would then change to reflect whatever we end up doing. Count two, any problem with how count two is listed there?
No.
Reserving our earlier objections, no.
And then count three, I think the language,
I think you just have to add under the first question.
yeah,
To answer yes, you must agree on the violation that caused death.
yeah, I would put it, yeah, I would put exactly the same line. For some reason, we just don't have that there, but that would be the one change I would make. It would say, to answer yes, you must agree on the violation that caused death. Yeah. That makes sense, Mr. Zachar?
Yes?
Okay. I'm going to make those changes. We're going to go make those changes, and then I'll be right back, and we'll do that last little part. Otherwise, I think we're doing good on the.
Yeah, does the court want to address the verdict forms now, or?
That is the I'm going to address the verdict forms and change one. We would change it to what we just talked about. Or is there another issue?
Yeah, my request would be to require a four-person signature under the jury questions as well on count three.
Any objection to that?
Sure, that's fine.
Okay.
I mean, no objection.
Yeah. All right, we'll try a four-person signature. Okay, well, we'll have to figure out how to do that format. All right, I'll be right back. Maybe seated. We're gonna get the official ones in a bit. Tell me when you're ready. All right. So everybody's present in the courtroom. The court has, sorry it's taken this long. We reconfigured the verdicts. We've now changed 484. I believe I've given the parties copies of that. There wasn't any mistakes on the, I say that now, but that were noticed at this point in time. If we're incorporating that into the jury instructions, we'll make the copies for the jury. That's going to take another 10 minutes or so. And these are the verdicts. It doesn't have to be the final verdict. Hopefully it's right because it's pretty much what's at 484.
I would note.
Where's the mistake?
The verdict offers an option to convict on second-degree intentional.
Oh, yep, you're right. The 40. What the heck?
Yeah, my request with the verdict would be just like one single verdict form for each count: first degree reckless, second degree reckless, and then not guilty.
Oh, really? I thought you wanted them all in a row.
No, yeah.
I agree with how Attorney Zachar is.
Yeah.
Having one form for each of them as to guilty, and then not guilty that covers all of them. As a count one.
Yeah, I'm sorry if I wasn't clear on that. That was
So you want one page,
one
essentially?
page, yes.
Okay. That is a change. All right. What about count two? I hate to say it, but Christina had it that way, and I made her change it. She might not be happy with me on that one.
Blame it on me, Judge.
Sure. I usually do. Don't worry.
I think count two looks.
I'm fine with that. I mean, if we want to keep consistency, we can break it back up again, but count two is as is.
Most verdicts, we do this.
Yeah.
We don't break it.
Yeah, I think it's fine in count two.
Yeah. And then count three. And there's 2 pages. Not guilty's on the second page.
Count three looks fine to me.
Okay. Let me go change count one. Be right back. Yeah. I just realized it's completely wrong. I was changing it. I wonder what happened with it.
It is right in the actual instruction, so I don't know.
Yeah, there must have been a glitch when we. Oh, we'll get it. Here's, I forgot to, these are count one modified. Without the not guilty, the not guilty recap. This is an extra. I don't know if you wanted that one. So lunch may not be till noon anyway. Yeah, that one I'll deal with it later. Okay. Yeah, actually, why don't we give her that extra copy? Here's the extra copy. Okay. All right, you ready to go on record? Okay, all the parties are present. What you have in front of you is a copy of the jury instructions. The verdicts we changed to what we had just talked about. I don't know if the states had an opportunity to glance over it.
I did. I'm assuming you have the not guilty one and just gave us the 3 guilty.
Right, I just gave you the 3 guilties.
Yeah, that was my question as well.
Yeah, we have the 4 pages on the count one. We just didn't reprint that one. And then the other, so what the plan is right now is I'm going to read the instructions. We have lunch coming early. We'll probably have you come back. It depends on when I get done here, 12:30, 1:45, and then we'll do closings. Does that make sense? And I will also apologize for the court being slow this morning. But anything else from the state and defense?
Oh, yeah.
Let's bring the jury in. Oh, it took way too long. All right, everybody may be seated. Best laid plans. We always thought we had this pretty well in hand, and then things didn't go right. It's my fault. Part of it is that we had a misunderstanding of certain things, and we had a glitch. So I apologize for the late wait and the long wait. So I'll just to explain to you what we're going to do right now. So I'm going to do the jury instructions as the last part I read at the very end after closings. Do the jury instructions. Have you eat lunch, and then we'll probably bring you back hopefully a little bit early. Then we do closings. There is a limit on the closings, so it won't go for 2 days or 3 days. It's going to go for a few hours, though, to give everybody an opportunity to say what needs to be said. So, having done that, let's start with the jury instructions. As you can see, it's very long. You will get copies of this for the jury room when you're deliberating, too. But let's start with these instructions. Members of the jury, the court will now instruct you on the principles of law which you are to follow in considering the evidence in reaching your verdict. It is your duty to follow all these instructions. Regardless of any opinion you may have about what the law is or ought to be, you must base your verdict on the law I give you in these instructions. Apply the law to the facts in the cases which have in the case which have been properly proven by the evidence. Consider only the evidence received during the trial. The law as I given to you by these instructions and from these alone, guided by your soundest reason and best judgment, reach your verdict. If any member of the jury has an impression of my opinion as to whether the defendant is guilty or not guilty, disregard that impression entirely and decide the issues of facts solely as you view the evidence. You, the jury, are the sole judges of the facts, and the court is the judge of the law only. The first count of the information in this case charges that count 1, first-degree intentional homicide, first-degree reckless homicide, second-degree reckless homicide, in section 940.01, parent 1, parent A, 940.02, parent 1, in the Wisconsin in 10.18. Josie Dikeman, on or about Saturday, February 11th, 2023, at County Road OS in the town of Madera, La Crosse County, Wisconsin, did cause the death Alexavier Pedrin, date of birth 7/10/2016, with intent to kill that person or another, contrary to 940.01, parent 1, parent A, with stats. To this charge, Josie Dikeman has entered the plea of not guilty, which means the state must prove every element of the offense charged beyond a reasonable doubt. Crimes to consider. The information charges Josie Dikeman with first-degree intentional homicide. You must first consider whether Josie Dikeman is guilty of that offense. If you're not so satisfied with that Josie Dikeman is guilty of first-degree intentional homicide, you must consider whether or not Josie Dikeman is guilty of first-degree reckless homicide or second-degree reckless homicide, which are less serious degrees of criminal homicide. Intentional and reckless homicide. The crime referred to as first-degree intentional, first-degree reckless, and second-degree reckless homicide are different types of homicide. Homicide is the taking of life of another human being. The degree of homicide defined by law depends on the facts and circumstances of each particular case. While the law separates homicides into different types and degrees, there are certain elements which are common to each crime. Both intentional and reckless homicide require that Josie Dikeman caused the death of Alexavier Pedrin. First-degree intentional homicide requires that the state to prove that Josie Dikeman acted with intent to kill. First-degree reckless homicide and second-degree reckless homicide require that Josie Dikeman acted recklessly. First-degree reckless homicide required proof of one additional element, that the circumstances of the Josie Dikeman's conduct showed utter disregard for human life. It is for you to decide what type of homicide Josie Dikeman is guilty, if guilty at all, according to the instructions which define the two offenses. Statutory definition of first-degree intentional homicide. First-degree intentional homicide is defined in Stats 940.01 is committed by one who causes the death of another human being and with intent to kill that person or another. State's burden of proof. Before you may find Josie Dikeman guilty of first-degree intentional homicide, the state must prove by evidence which satisfies you beyond a reasonable doubt that the following two elements were present. Elements of first-degree intentional homicide the state must prove. 1, Josie Dikeman caused the death of Alexavier Pedrin. Cause means that Josie Dikeman's act was a substantial factor in producing the death. 2, Josie Dikeman acted with intent to kill Alexavier Pedrin. Intent to kill means that Josie Dikeman had the mental purpose to take the life of another human being or was aware that her conduct was practically certain to cause the death of another human being. When may intent exist? While the law requires that Josie Dikeman acted with intent to kill, it does not require that the intent existed for a particular length of time before the act is committed. The act need not be brooded over, considered, or reflected upon for a week, a day, an hour, or even a minute. There need not be any appreciable time between the formation of the intent and the act. The intent to kill may be formed at any time before the act, including the instant before the act, and must continue to exist at the time of the act. Deciding about intent. You cannot look into Josie Dikeman's mind to find intent. Intent to kill must be found, if found at all, from Josie Dikeman's acts, words, and statements, if any, and from all the facts and circumstances in the case bearing upon intent. Intent and motive. Intent should not be confused with motive. While proof of intent is necessary to a conviction, proof of motive is not. Motive refers to a person's reason for doing something. While motive may be shown as a circumstance to aid in the establishing the guilt of a defendant, the state is not required to prove motive on the part of the defendant in order to convict. Evidence of motive does not by itself establish guilt. You should give it the weight you believe it deserves under all the circumstances. Jury's decision. If you're satisfied beyond a reasonable doubt that Josie Dikeman caused the death of Alexavier Pedrin with the intent to kill, you should find Josie Dikeman guilty of first-degree intentional homicide. If you're not so satisfied, you must find Josie Dikeman not guilty of first-degree intentional homicide, and you should consider whether Josie Dikeman is guilty of first-degree reckless homicide in violation of Stats 940.02 parent 1, which is a lesser included offense of first-degree intentional homicide. Make every reasonable effort to agree. You should make every reasonable effort to agree unanimously on the charge of first-degree intentional homicide before considering the offense of first-degree reckless homicide. However, if after full and complete consideration of the evidence, you conclude the further deliberation would not result in unanimous agreement on the charge of first-degree intentional homicide, you should consider whether Josie Dikeman is guilty of first-degree reckless homicide. Statutory definition of first-degree reckless homicide. First-degree reckless homicide is defined in Wisconsin Statute 940.02 parent 1, is committed by one who recklessly causes the death of another human being under circumstances which show utter disregard for human life. State's burden of proof. Before you may find Josie Dikeman guilty of first-degree reckless homicide, the state must prove by evidence which satisfies you beyond a reasonable doubt that the following three elements were present. Elements of first-degree reckless homicide the state must prove. 1, Josie Dikeman caused the death of Alexavier Pedrin. Cause means that Josie Dikeman's act was the substantial factor in producing the death. 2, Josie Dikeman caused the death by criminally reckless conduct. Criminally reckless conduct means the conduct created to a risk of death or great bodily harm to another person. The risk of death or great bodily harm was unreasonable and substantial, and the defendant was aware that her conduct created the unreasonable and substantial risk of death or great bodily harm. 3, the circumstances of Josie Dikeman's conduct show utter disregard for human life. In determining whether the circumstances of the conduct showed utter disregard for human life, consider these factors: what Josie Dikeman was doing, why Josie Dikeman was engaged in the conduct, how dangerous was the conduct was, how obvious the danger was, whether the conduct showed any regard for life, and all other facts and circumstances relating to the conduct. Consider also Josie Dikeman's conduct after death to the extent that it helps you decide whether or not the circumstances showed utter disregard for human life at the time of the death occurred. Jury's decision. If you are satisfied beyond a reasonable doubt that Josie Dikeman caused the death of Alexavier Pedrin by criminal reckless conduct and that circumstances of the conduct showed utter disregard for human life, you should find Josie Dikeman guilty of first-degree reckless homicide. If you're not so satisfied, you must find Josie Dikeman not guilty of first-degree reckless homicide, and you should consider whether Josie Dikeman is guilty of second-degree reckless homicide in violation of Wisconsin Statute 940.06, which is a lesser included offense of first-degree reckless homicide. Make every reasonable effort to agree. You should make every reasonable effort to agree unanimously on the charge of first-degree reckless homicide before considering the offense of second-degree reckless homicide. However, if after full and complete consideration of the evidence, you conclude the further deliberation would not result in unanimous agreement on the charge of first-degree reckless homicide, you should consider whether the defendant is guilty of second-degree reckless homicide. Statutory definition of second-degree reckless homicide. Second-degree reckless homicide is defined under Wisconsin Statute 940.06, is committed by one who recklessly causes the death of another human being. Difference between first and second-degree reckless homicide. The difference between first and second-degree reckless homicide is that first-degree offense requires proof of one additional element, that the circumstance of Josie Dikeman's conduct showed utter disregard for human life. Jury decision. If you're satisfied beyond a reasonable doubt that all the elements of first-degree reckless homicide were present, except the element requiring that the circumstance of the conduct showed utter disregard for human life, you should find Josie Dikeman guilty of second-degree reckless homicide. In other words, if you're satisfied beyond a reasonable doubt that Josie Dikeman caused the death of Alexavier Pedrin by criminally reckless conduct, you should find Josie Dikeman guilty of second-degree reckless homicide. If you're not so satisfied, you must find Josie Dikeman not guilty. You are, in any event, to find Josie Dikeman guilty of one or more offense as to count one. I'm going to just repeat that. You are not, in any event, to find Josie Dikeman guilty of one or more offense as to count one. Count two, chronic neglect of child consequence is death. Josie Dikeman, between January 1st, 2021 and February 11th, 2023, at County Road OS in the town of Madera, La Crosse County, Wisconsin, being a person responsible for the welfare of a child, Alexavier Pedrin, through her action or failure to take action for reasons other than poverty, did negligently fail to provide necessary care so as to seriously endanger the physical, mental, or emotional health of the child, and the child suffered death as a consequence, and the actor is guilty of chronic neglect as she committed 3 or more violations under 948.21 parent 2, with a specific period of time involving the same child, to wit, Alexavier Pedrin, contrary to 948.215 parent 1 and parent 2, parent A, Wisconsin statutes. To this charge, Josie Dikeman has entered a plea of not guilty, which means the state must prove every element of the offense charged beyond a reasonable doubt. Statutory definition of the crime. Section 948.215 of the Criminal Code of Wisconsin is violated by one who commits 3 or more violations of Section 948.21 parent 2 within a specific period of time involving the same child. State's burden of proof. Before you may find Josie Dikeman guilty of this offense, the state must prove by evidence which satisfies you beyond a reasonable doubt that the following 3 elements were present. Elements of the crime that the state must prove. 1, Josie Dikeman committed 3 or more violations of Section 948.21 parent 2 involving Alexavier Pedrin. Section 948.21 parent 2 of the Criminal Code of Wisconsin is violated by any person who is responsible for the child's welfare who, through action or failure to take action for reasons other than poverty, negligently fails to provide any of the following so as to seriously endanger the physical, mental, or emotional health of the child, necessary care, necessary food, necessary medical care, education in compliance with Section 118.15, or to drug abuse, as defined on 46.973, parent 1, parent B. Elements of Section 948.21 involving the same child. A, Alexavier Pedrin had not obtained the age of 18. Knowledge of Alexavier Pedrin's age is not required, and mistake regarding Alexavier Pedrin's age is not a defense. B, Josie Dikeman was a person responsible for the welfare of Alexavier Pedrin. A person responsible for the welfare of a child includes a person who is employed or used by one legally responsible for the child's welfare to exercise temporary control or care of the child. B, Josie Dikeman, through action or failure to take action, and for reasons other than poverty, failed to provide the necessary care, necessary food, necessary medical care, education in compliance with Section 118.15, or to drug abuse as defined under Section 46.973, parent 1, parent B. Section 118.15 of the Wisconsin statute is violated by a person who has under her control a child between the age of 6 and 18 years and fails to cause the child to attend school regularly during the full period and hours that the school is in session until the end of the school term, quarter, or semester of the school year in which the child becomes 18 years of age. Section 46.973, parent 1, parent B, the Wisconsin statute states, drug abuse means the use of drug in such manner as to endanger the public health, safety, or welfare. D, failure to provide seriously endanger the physical, mental, or emotional health of the child. To seriously endanger means to create a serious risk of harm or injury. E, the failure to provide was negligent. Negligent means acting or failing to act in such a way that a reasonable person would know or should know seriously endangers the physical, mental, or emotional health of a child. Element 2, at least 3 violations of neglect as previously defined involving Alexavier Pedrin took place within a specific period of time. The specific period of time is from January 1st, 2021 through February 11th, 2023. More than 3 acts alleged. Before you may find Josie Dikeman, you must unanimously agree that at least 3 violations of Section 948.21 involving the same child occurred between January 1st, 2021 and February 11th, 2023, but you need not agree on which acts constitute the required 3. Element 3, Alexavier Pedrin suffered death as a consequence. Jury's decision. If you're satisfied beyond a reasonable doubt that all 3 elements of this offense have been proved, you should find Josie Dikeman guilty. If you're not so satisfied, you must find Josie Dikeman not guilty. The third count of the information in this case charges that count 3, physical abuse of a child, repeated acts causing death, 948.03, parent 5. Josie Dikeman between January 1st, 2021 and February 11th, 2023 at County OS in the town of Madera, La Crosse County, Wisconsin, did commit repeated acts of physical abuse involving Alexavier Pedrin, where at least 3 of the acts were violation of 948.03, parent 2 Wisconsin statutes. And at least 1 violation caused the death of Alexavier Pedrin, contrary to 948.03, parent 5, parent A, 1 of Wisconsin statutes. Statutory definition of crime. Just a second. Section 948.03, parent 5 of the Criminal Code of Wisconsin is violated by one who, within a specific period of time, commits 3 or more acts of physical abuse of a child, of the same child. State's burden of proof. Before you may find Josie Dikeman guilty of this offense, the state must prove by evidence which satisfies you beyond a reasonable doubt that the following 2 elements were present. Elements of the crime the state must prove. 1, Josie Dikeman committed at least 3 acts of physical abuse of Alexavier Pedrin. In this case, Josie Dikeman is alleged to have committed physical abuse of a child by violating Section 948.03, Parent 2, Parent B. Physical abuse of a child, as defined by 948.03, Parent 2, Parent B of the Criminal Code of Wisconsin, is committed by one who intentionally causes bodily harm to a child. Before you may find Josie Dikeman guilty of committing an act of physical abuse of a child, the state must prove by evidence which satisfies you beyond a reasonable doubt the following 3 elements were present to establish an act of physical abuse of a child. A, Josie Dikeman caused bodily harm to Alexavier Pedrin. Bodily harm means physical pain or injury, illness, or any impairment of physical condition. B, Josie Dikeman intentionally caused bodily harm. This requires that Josie Dikeman had the mental purpose to cause bodily harm to Alexavier Pedrin, or was aware that her conduct was practically certain to cause that result. C, Alexavier Pedrin had not obtained the age of 18 at the time of the offense. Knowledge of Alexavier Pedrin's age is not required, and mistake regarding Alexavier Pedrin's age is not a defense. Element 2, at least 3 acts of physical abuse took place within a specific period of time. The specific period of time is from January 1st, 2021 through February 11th, 2023. More than 3 acts alleged. Before you may find Josie Dikeman guilty, you must unanimously agree that at least 3 acts of physical abuse occurred between January 1st, 2021 and February 11th, 2023. But you need not agree on which acts constitute the required 3. Jury's decision. If you're satisfied beyond a reasonable doubt that Josie Dikeman committed 3 violations in 948.03, Parent 2, Parent B within the specific period of time, you should find Josie Dikeman guilty. If you find Josie Dikeman guilty, you must answer the following question. Did at least 1 violation cause the death of Alexavier Pedrin? You must all agree on the violation that caused death. If you're not so satisfied, you must find Josie Dikeman not guilty. If you cannot agree on the violation that caused death, you should consider the following question. Did at least 1 violation result in great bodily harm to Alexavier Pedrin? Great bodily harm means bodily injury which creates a substantial risk of death, or which causes serious permanent disfigurement, or which causes a permanent or protracted loss of or impairment of the function of any body member or organ or other serious bodily injury. If you cannot agree on the violation that caused death, you should consider whether a violation resulted in great bodily harm. To answer yes, you must agree on the violation that caused the great bodily harm. In reaching your verdict, examine the evidence with care and caution. Act with judgment, reason, and prudence. Presumption of innocence. Defendants are not required to prove their innocence. The law presumes every person charged with the commission of an offense to be innocent. The presumption requires a finding of not guilty unless in your deliberations you find it is overcome by evidence which satisfies you beyond a reasonable doubt the defendant is guilty. State's burden of proof. The burden of establishing every fact necessary to constitute guilt is upon the state. Before you can return a verdict of guilty, the evidence must satisfy you beyond a reasonable doubt the defendant is guilty. Reasonable hypothesis. If you can reconcile the evidence with any reasonable hypothesis consistent with the defendant's innocence, you must do so and return a verdict of not guilty. Meaning of reasonable doubt. The term reasonable doubt means a doubt based upon reason and common sense. It is a doubt which a reason can be given arising from a fair and rational consideration of the evidence or lack of evidence. It means such a doubt that would cause a person of ordinary prudence to pause or hesitate when called upon to act in the most important affairs of life. A reasonable doubt is not a doubt which is based on mere guesswork or speculation. A doubt which arises merely from sympathy or from the fear to return a verdict of guilt is not a reasonable doubt. A reasonable doubt is not a doubt such as that may be used to escape the responsibility of a decision. While it is your duty to give the defendant the benefit of every reasonable doubt, you are not to search for doubt. You are to search for the truth and give the defendant the benefit of any reasonable doubt that remains after carefully considering all the evidence. An information is nothing more than a written formal accusation against the defendant charging the commission of one or more criminal acts. You are not to consider it as evidence against the defendant in any way. It does not raise any inference of guilt. Evidence is, first, the sworn testimony of witnesses, both in direct and cross-examination, regardless of who called the witnesses. Second, the exhibits the court has received, whether or not the exhibits go to the jury room. Third, any facts which the lawyers have agreed or stipulated or which the court has directed you to find. Anything you may have seen or heard outside of the courtroom is not evidence. You are to decide the case solely on the evidence offered and received at trial. It is not necessary that every fact be proved directly by a witness or an exhibit. In fact, a fact may be proved indirectly by circumstantial evidence. Circumstantial evidence is evidence which a jury may logically find other facts according to common knowledge and experience. Circumstantial evidence is not necessarily better or worse than direct evidence. Either type of evidence can prove a fact. Whether evidence is direct or circumstantial, it must satisfy you beyond a reasonable doubt that the defendant committed an offense before you may find the defendant guilty. An exhibit becomes evidence only when received by the court. An exhibit marked for identification and not received is not evidence. An exhibit received is evidence whether or not it goes to the jury room. Evidence presented for Josie Dikeman. Evidence has been presented regarding the conduct of Josie Dikeman for which she is not on trial. You may consider the evidence only for the limited purpose and not to conclude that Josie Dikeman has a bad character or a general tendency to commit crimes. You must not use this evidence to decide that because Josie Dikeman allegedly committed another act at some other time, Josie Dikeman must have committed the offense now charged. Specifically, evidence has been presented that Josie Dikeman was involved in prior incidents in 2011 and 2013. If you find that conduct did occur, you should consider it only on the issue of identity. You may not consider this evidence to conclude that Josie Dikeman has a certain character or a certain character trait that Josie Dikeman acted in conformity with that trait or character with respect to the offense charged in this case. Definition for Josie Dikeman. The evidence was received on the issue of identity. Is the prior conduct of Josie Dikeman so similar to the offense charged that it tends to identify Josie Dikeman as the one who committed the offense charged? Evidence presented for Derek Pedrin. Evidence was presented regarding conduct of Derek Pedrin, specifically that Derek Pedrin was physically abusive to Josie Dikeman, Alexavier Pedrin, and other children in the home, and that Derek Pedrin purchased and used alprazolam, Xanax. If you find this conduct has occurred, you should consider it only to the issue of motive, opportunity, intent, identity, context, and source of injuries. You may not consider the evidence to conclude that Derek Pedrin has a certain character or a certain character trait, and that Derek Pedrin acted in conformity with the trait or character. Definitions for Derek Pedrin. The evidence was received on the issue of motive, that is, whether Derek Pedrin has a reason to desire the result of the conduct alleged. Opportunity, that is, whether Mr. Pedrin had an opportunity to commit the conduct alleged. Intent, that is, whether Mr. Pedrin acted with a state of mind that is required for the conduct alleged. Identity, that is, whether the prior conduct of Mr. Pedrin is so similar to the conduct alleged that it tends to identify Mr. Pedrin as the one who committed the conduct alleged. Context or background, that is, to provide more complete presentation of the evidence relating to the conduct alleged. Propensity-free reasoning requirement. To use this evidence properly, Your reasoning must be propensity-free, that you must not reason in this way. Because Josie Dikeman committed another act or crime, she probably acted in the same way again. That kind of reasoning is forbidden. If you cannot follow this propensity line of reasoning, you must disregard the other acts and evidence entirely. You may consider the evidence only for the purpose I have described, giving it the weight you determine it deserves, and not to be used to conclude that Josie Dikeman is a bad person and for that reason is guilty of the offense charged. Remarks of the attorneys are not evidence. The remarks suggested certain facts not in evidence disregard the suggestion. Attorneys for each side have the right and the duty to object to what they consider are proper questions asked of witnesses and to the omission of other evidence which they believe is not properly admissible. You should not draw any conclusions from the fact an objection was made. By allowing testimony or other evidence to be received or the objection of counsel, the court is not indicating any opinion about the evidence. You jurors are the judges of the credibility of the witness and the weight of the evidence. Disregard entirely any question that the court did not allow to be answered. Do not guess what the witness's answer might have been. If the question itself suggests that certain information might be true, ignore the suggestion and do not consider it as evidence. During the trial, the court has ordered certain testimony be stricken. Disregard all stricken testimony. You have heard and viewed an audiovisual recording. Recordings are proper evidence, and you may consider them just as any other evidence. You may consider the actions of a person, facial expressions, and lip movements that you can observe on videotapes to help you to determine what was actually said and who said it. The weight of evidence does not depend on the number of witnesses on each side. You may find the testimony of one witness is entitled to greater weight than that of another witness, or even of several other witnesses. In weighing the evidence, you may take into account matters for your common knowledge and your observation and experiences in the affairs of life. Ordinarily, a witness may testify only about facts. However, a witness with specialized knowledge in a particular field may give an opinion in that field. In determining the weight you give to this opinion, you should consider the qualifications and credibility of the witness, the facts upon which the opinion is based, and the reason given for the opinion. Opinion evidence was received to help you reach a conclusion. However, you're not bound by any witness's opinion. During the trial, a witness was told to assume certain facts and then was asked for an opinion based upon that assumption. This is called a hypothetical question. The opinion does not establish the truth of the facts which upon it is based. Consider the opinion only if you believe the assumed facts upon which it is based have been proved. If you find the facts stated in the hypothetical questions have not been proved, then the opinion based on those facts should not be given any weight. It is the duty of the jury to scrutinize and to weigh the testimony of witnesses and to determine the effect of evidence as a whole. You are the sole judges of the credibility, that is, the believability of witnesses, and the weight to be given to their testimony. In your determination of credibility, you must avoid bias, conscious or unconscious, based on the witness's race, national origin, religion, age, ability, gender identity, sexual orientation, education, income level, or any other physical characteristic. And determine the credibility of each witness and weight you give to the testimony of each witness. Consider these factors. Whether the witness's interest or lack of interest in the result of this trial, the witness's conduct, appearance, and demeanor on the witness stand, the clearness or lack of clearness of the witness's recollections, the opportunity the witness had for observing and for knowing the matter the witness testified about, the reasonableness of the witness's testimony, the apparent intelligence of the witness, bias or prejudice, if any has been shown, possible motives for falsifying testimony, and all other facts and circumstances during the trial which tend either to support or discredit testimony. Then give to the testimony of each witness the weight you believe it should receive. Josie Dikeman has testified in this case. You should not discredit the testimony just because Josie Dikeman is charged with a crime. Use the same factors to determine the credibility and weight of Josie Dikeman's testimony that you use to evaluate the testimony of any other witness. There is no magic way for you to evaluate the testimony. Instead, you should use your common sense and experience. In everyday life, you determine for yourself the reliability of things people say to you. You should do the same thing here. Evidence has been received that some of the witnesses in this trial have been convicted of crimes. This evidence was received solely because it bears upon the witness's character for truthfulness. It is not to be used for any other purpose. Evidence has been received that Josie Dikeman had been convicted of a crime. This evidence has been received solely because it bears upon Josie Dikeman's character for truthfulness as a witness. It must not be used for any other purpose, and particularly you should bear in mind the criminal conviction at some previous point, let me say that again, at some previous time is not proof of guilt of the offense now charged. The testimony of a child should be weighed in the same manner as testimony of any other witness. Considerations of age, intelligence, ability to observe and report correctly, ability to understand the questions and the answer to them, sense of duty to speak the truth, conduct on the witness stand, interest, appearance, and other matters bearing on the credibility applied to a child witness in common with all other witnesses. Now, the next two parts I will read when we get to the closing arguments. Because of the timing of this, what we're going to do is we'll take a break right now, have you have lunch. I would like to start at a quarter to one, so it gives you a little less than an hour, so we can get to the closing arguments. Please still don't talk about the case, even though I'm halfway through the jury instructions, but we'll have lunch and we'll have you come back and we'll go from there. See you then. Could you leave those here for right now? Yeah, leave them here. Thank you for asking. All right, everybody be seated. Is there any problem with the way I read the instructions so far? Defense?
Oh, yeah.
There was one word I changed, by the way. There was a "the" that was sort of misplaced, but it was pretty minor. So be back at, let's say, 22, so we can start right up at quarter to.
You're good.
Thank you.
Please rise.
Okay. All the parties are present. Just one question before we bring the jury in. We'll start with closings by the state. Probably take a break between the state and the defense. If we need a break, we'll probably take another break at that point. I'm guessing we're aiming for probably 4 o'clock to be done, given the limitation I put out on the closings for an hour and a half. What I anticipate is saying to the jury, just so you know, start your deliberations, but we'll break at 5:30 tonight, so they don't feel like they have to go all night. I'm changing the capital plan. My guess is they'll want to do that because I think these are very complex questions and a lot of evidence and stuff, so it'll take them some time anyway. But at 5:30, I would have to bring them back so you'd be here and give them a break and then, you know, tell them not to talk about it, think about it, et cetera, until tomorrow morning. We'd start up at 8:30 tomorrow morning. The question I have, well, I can ask this later, is that, think about it, is if we need to have them meet here, usually I have them go right to the room and start deliberating. I don't have them come back into the courtroom. Everybody okay with that process?
Yes.
Okay. Okay. So anything we need to talk about before we bring the jury in?
No, Your Honor.
All right, let's bring the jury in. Everybody may be seated. All right. Let's, it's time for closing arguments, and so we'll start with the state. Go ahead, Mr. Toberson.
Good afternoon, ladies and gentlemen. On February 11th of 2023, this defendant forever silenced the voice of Alexavier J. Pedrin, or as you've come to know him through this trial, Alex. On February 11th of 2023, this defendant extinguished Alex through her brutal assault and her intentional drugging. Alex's voice cannot tell you what happened, but Alex's body is screaming out to you that he was abused and he was drugged. You saw the graphic photos displayed of Alex at autopsy. You saw the bruising on his body on multiple planes on both sides of his face and head, and throughout all sides of his scalp, including on the top of his head. That was this defendant's stamp of abuse. You heard the levels of Xanax inside of his body. That was so this defendant could quiet his cries. Alex suffered in his final hours as he bled internally from inside of his abdomen. The Xanax slowed his respiratory system. Every breath that he took was pained by that rib fracture he had. With less blood to deliver oxygen throughout his body, his brain swelled and his body began to shut down until Alex took his last breath. At 9:44 a.m. on February 11th of 2023, Alexavier J. Pedrin was declared deceased. If Alex were alive today, he would be 9 years, 10 months, and 4 days old. He would be finishing the 4th grade. Alex is missed by brothers and sisters. Alex's death has left a hole in the heart of his mother, Jenna Love, and his father, Derek Pedrin. Through this defendant's abuse and intentional drugging, this community, your community, has forever lost the potential of Alex's life and what it could have been. Alex mattered. This trial process is about protecting the defendant's constitutional rights and proving that this defendant is responsible for Alex's abuse, Alex's neglect, and his death. At 9:25 a.m. on February 11th of 2023, this defendant called 911. You know it because you heard it. According to that call, she woke up to find Alex on the ground. Twice during that call, she represents that Alex's body was on the ground. She says that Alex was unresponsive and that there was an open bag of her medication on the floor. The defendant reported that she tried CPR on Alex's body to no avail, and that Alex was not breathing. As that 911 call is taking place, deputies Jar and Anderson arrive on scene. It's perhaps one of the fastest responses one could see to a 911 call. The person is still on the call, and the deputies are arriving on scene. When they arrive and this defendant opens the front door, Alex's body is on the bed, not the floor. There is a white sheet under his body to protect the bed from any accidents during the previous evening. That white sheet is undisturbed. It tells you that after Alex was put on that white sheet and in that bed, he did not move to the floor again. It's where he died. Alex's body was in rigor. His left hand was tucked inside of his pants, and his right hand was up towards his head. The left hand being tucked into his pants tells you that his body was not moved from the floor to the bed. As Deputy Jar touched Alex's body and rotated it onto its side, you saw the black substance start to leak out of the side of his mouth. That small movement of just rotating his body to one side caused that substance to start coming out of his mouth. That tells you that this defendant never performed CPR. It was a lie. This defendant told Sergeant Williams that she performed CPR for upwards of 10 minutes. You observed Deputy Jar actually perform CPR and what happened when he just started to perform CPR. You saw the substance start to ooze out from Alex's mouth. And then as the body was moved to the floor, how it continued to ooze out and pool behind his head. That tells you there was no CPR before Deputy Jar arrived on scene. This defendant also said, when she was on the stand, that after trying to perform CPR, she held Alex's body in her arms and cried. You saw the simple movement of moving his body to the side. The simple movement of holding his body in her arms would have caused that same reaction. This defendant didn't hold Alex's body. This defendant didn't cry. You saw her face when the door was opened. Through the investigation into this case, you know that this defendant texted Laura Lee Raines at 9:07 a.m. According to the defendant, she did not immediately notice Alex was not on the bed. You know from the forensic interviews of both Araya and Brantley that they slept upstairs. You know from the testimony of Brantley that he verified once again that he slept upstairs. There were only 2 people in the bed on the evening of February 10th, 2023. This defendant and Alex. And as soon as this defendant woke up, if what this defendant was reporting was true, she would have known immediately that Alex's body was not in that bed. But Alex's body was in that bed. It just wasn't moving. Because he was dead. The children tell you that's what happened. The scene investigation tells you that's what happened. Alex's body tells you that's what happened. Your common sense tells you that is what happened in this case. At 9:20 in the morning, this defendant texts Rafael Suarez. "Something is wrong with my son. Don't come." The text message to Rafael Suarez, the person that she's supposed to go on a date with, goes out before she calls her own mother about Alex. The text message about Rafael Suarez saying don't come over regarding her date goes out before she calls 911. At 9:21 a.m., the defendant calls her mother, not 911. For 52 seconds, they talk. And then over 3 minutes pass after that phone call to her mother, where the testimony establishes that the defendant's mother instructed her to call 911. 3 minutes plus pass until at 9:25 and 52 seconds, she calls 911. There's only one person in the whole world who could have drugged Alex. That person's in the room, and she's seated at that table. Common sense tells you that medication that you take anytime takes effect within an hour or two. The amount of Xanax in Alex's system, you heard through the defense expert witness, was enough to potentially cause the death of an adult. That tells you about the amount of Xanax in a 6-year-old child's system. This isn't candy. This isn't something that you munch on. This is bitter pills. And they're inside of a 6-year-old child's body. It is impossible for Derek to have drugged Alex. Because if Derek did it, he left the house at 7:15 when he was arrested. If he drugged Alex, Alex would have been feeling the effects of Xanax by 8 to 9 o'clock. He would have been unconscious by 9 to 10 o'clock, dead by 11 to midnight at the latest. It is impossible. You know that Alex was awake until 3 a.m. That's what the defendant said repeatedly and did not deny when she took the stand. You know that she tried to put Alex to sleep around midnight, and he was still awake to the point that she turned the TV back on, and she continued to text Rafael Suarez. You know that Alex was actually awake because Laura Lee Raines heard over the phone Alex's voice saying what he wanted to do that evening. Alex was awake. Alex was alive. He was well. There's only one person in the whole world who could have staged the scene knowing that Alex had drugs in his system. That person is in this room, and it is the defendant. This defendant told you that she believes the bag that had the medication was up high. That was her testimony just yesterday. Her belief is that that bag was in a place where only adults could reach it. Derek was in jail that night. The only person that had the opportunity and the ability to take that bag and stage that scene is this defendant. This defendant knows what's inside of that bag because it's her medication. She's the only person that had both the opportunity and the ability to stage that scene. Both forensic pathologists that testified in this case agreed that Alex had Xanax in his system after he was beaten. Alex was brutally beaten first, and after he was brutally beaten, that's when the Xanax was in his system. After Alex is brutally beaten, you know that he already has a fractured leg and limited mobility. The beating left him with a broken rib that brought pain to him with every breath. You know that he had abdominal pain with a laceration to his liver and bleeding into the mesentery cavity. You know that that pain would increase over time. You know that he had multiple blows to his head and to his body. For Alex, movement would have meant more pain. And he couldn't even access a bag that was at a height that only adults could grab it. Only this defendant could have done that. The person who administered that drug to Alex would have to know that he was beaten. He would have to know and want to silence him after he was beaten. And they would have the ability and be the only person that had the ability to stage the scene, to put the bag out, to dump the pills inside of the bag, and put the empty canister of the prednisone by Alex's body. The scene investigation conducted by law enforcement verifies that the scene was staged. Every bottle inside that bag had the child safety locks engaged. The pills inside of every single one of those bottles inside the bag matched. The pill bottle outside of the bag had pills inside the bag that matched the prescription. 10 of 12 dumped on the inside of the bag. For you to believe that after Alex was brutally beaten, he would grab and access this bag and then find medication in that bag, you would have to believe that he would A, be able to open the bag and unzip it after being beaten, B, engage the child safety lock, C, empty out all the pills in the bag except for the pills that were Xanax, and somehow magically ingest only the Xanax, and Xanax at a level that would kill an adult potentially. Those are the facts that the defense is trying to sell you, and ladies and gentlemen, do not buy it. The scene investigation in this case also tells you so much more. Alex's pants are stained with cotton candy. There's an empty cotton candy container on the floor. There's also, if you look close enough, an empty can of Red Bull. And you know from the autopsy results that Alex had caffeine in his system. You know that it was a problem for this defendant that Alex would get up in the middle of the night. That's a problem that this defendant created. But Alex would get up in the middle of the night. And like any 6-year-old child, he sought sugar, he sought Red Bull, he sought the things that taste good. And so his pants are stained with cotton candy. The testimony of Investigative Sergeant Amundsen established that there was cotton candy particles throughout the bedroom. It stained the carpet, it was on the wood, The pieces that he had collected from the bed, he originally sees, and then he picks up and he says, this looks like cotton candy. It looks like what I'm seeing everywhere else.
Overruled. Keep on going.
You know from phone analysis that this defendant was texting Rafael Suarez during the evening of February 10th into the morning of February 11th over 160 times. Those text messages actually start at 6:18 p.m. while Derek is still at the residence. Derek arrives home from work sometime after 5:30 in the evening, and she is texting another man. And that's her right. You know that the relationship between Derek and this defendant is toxic, to say the least. But those text messages establish a number of things. That she's awake till just before 2 a.m., the last time she sends a message, and then after 2 a.m., when she's not texting Rafael Suarez, she and Alex are left awake and alone. This defendant beat Alex. The beating was a brutal beating. You saw the bruising on his body. During the welfare check conducted by Deputy Kerneen, he observed Alex, not once, but twice. He came into the residence and he saw one old injury above his eye and one bruise on the back of his leg. Deputy Kerneen also told you what Alex was wearing. The only thing that Alex was wearing at that time, when he looked a second time, was a pull-up diaper. The other thing that Deputy Kerneen told you is that between the two times when he saw Alex in the residence, Alex repositioned his body. He moved his body on the couch. No other bruising, no redness, no signs of tears or recent crying. And in this defendant's own words, Alex was asleep. In this defendant's own words, the next morning, to Sergeant Williams, Alex was asleep from 5 p.m. to 7:30 to 8 p.m., the entire time that Derek was home. That's consistent with what Derek told you when he took the stand. Derek said when he came home that there was a bucket of throw-up that he took and cleaned up. And then he was cleaning up around the house. Both of those facts were verified by Deputy Kerneen. Because when Deputy Kerneen comes over after conducting the welfare check, the bucket next to Alexavier is empty. The throw-up has been cleaned up. But when Deputy Kerneen arrives at the residence and he's looking in the windows, and Derek has no idea that law enforcement is there, Deputy Kerneen testified and told all of you Derek was sweeping and cleaning the kitchen, which is exactly what Derek said he was doing. Here, the defendant's own words seal her fate. You saw the text message at 9:06 p.m. that this defendant sent to Rafael Suarez. She said, "I just showered." That text message is in response to a message from Mr. Suarez asking, "What are you doing?" From 7:47 p.m. through 8:29 p.m., there is no activity on the defendant's cell phone. From 7:47 p.m. to 8:29 p.m., her phone with no activity is consistent with a person showering. What's more, the photograph that you saw this morning, the selfie, the first selfie that she took, is consistent with someone who got out of the shower within a half hour. Her hair still looks wet. She's got a bathrobe on. She has no makeup on her face. And then within 20 minutes, she has makeup on, her glasses on, but the same bathrobe on. She was improving her appearance because she was having an ongoing conversation with Mr. Suarez. But make no mistake about it, she showered. Why is that shower important? Because this defendant told you when she took the stand yesterday that she would never shower with dirty underwear and a bottle that was used for urine in the bathtub. The defendant wants you to believe that Derek came home, became angry at Alex for using the bathroom in his pants, took him into the bathroom, and brutally assaulted him. And she says the proof of that is the dirty underwear and the bottle that was in the tub. The dirty underwear and the bottle that were in the tub couldn't have been there when she showered. They came after the fact. It came after the fact because they were photographed the next morning. The defendant's story that Derek beat Alex in that bathroom is just that. It's a story. She's attempting to escape responsibility from her actions, something that you know she does from Dr. Endres. And this defendant herself changes the story. She went from showering earlier to not showering. Think about all the children that were home when this defendant says that that beating took place. Major is in the room right next door. He's been interviewed multiple times. He would have heard that brutal beating because this defendant reports that she heard it from upstairs. Brantley is home on that same floor. Araya is home. The defendant's story is not supported by Deputy Kerneen's observations. It's not supported by what this defendant originally reported to law enforcement, which is that Alex was asleep that entire time, which is completely supported by Deputy Kerneen's observations, which is completely supported by what Derek told all of you, which is completely supported by the scene with the garbage can being emptied and Derek sweeping. You also know it didn't happen because Laura Lee heard Alex's voice on that phone call at 10:30 in the evening. You also know it didn't happen because this defendant reported that Alex was fine that evening. Multiple times she told law enforcement. At the end of performing CPR, when Deputy Anderson tells the defendant that Alex is gone, the defendant's response is, how is that possible? He was fine. After being in this trial for the last 2.5 weeks, it's really easy to want to blame Derek Pedrin. You know that Derek Pedrin is violent with women. He is. You saw disturbing and disgusting conduct on multiple videos that involved Derek. At the beginning of this trial, during my opening statement, I told all of you, Derek is a domestic abuser, and by God, he is. Large portions of this trial actually felt like this trial was a domestic violence trial and Derek Pedrin was on trial. Perhaps one of the benefits of this trial be that Derek Pedrin was faced with his domestic violence in those videos and his conduct. Will it change his behavior? Who knows, but one can hope. But don't fall for this defendant's smokescreen. Do not let her use his domestic violence against her to allow her to get away with a homicide of a child. You were told during opening statements by the defense that there were going to be multiple witnesses, one of which was going to come in here and tell you that they witnessed Alexavier get struck and beat more than 12 times. That didn't happen.
Judge, completely improper objection.
Go on to, what? No, overruled. Go ahead.
You heard you're going to see multiple videos of the same. There's one video that's been admitted where Derek Pedrin is yelling horrible things at Alex inside that van. Things that are abusive. There's another video from years ago where the children are tapping their heads and they say, "Dad just hit me." Those are the two videos you saw that are supposed to establish that Derek is a child abuser. Context also matters. Deputy Paff, during his testimony, talked about a prior domestic violence offense that he responded to the residents just a week or so before. He talked about Alex and Derek's interaction during that time. In fact, it came up again because on the evening of February 10th, Derek said, "Can I say goodbye to my kids?" And the deputies say, "You remember how it went last time. We can't do it again for that reason." Days before, they could not pull Alex off of his father. They could not pull Alex off of Derek. And it created a situation for almost 20 minutes where law enforcement had to work to separate them. That encounter tells you what you need to know about Alex's relationship and love for his father. Make no mistake about it, Derek has responsibility. He has responsibility for Alex's neglect. He has responsibility for not getting Alex to the doctor on time. He has responsibility for not ensuring that Alex was attending school. He has responsibility for bringing drugs into the home for this defendant to use. But Derek's responsibility is not for you to decide today. You are deciding this defendant's responsibility. And his responsibility cannot be an excuse for this defendant to avoid responsibility for her actions. You have heard even more compelling evidence that this defendant is responsible for Alex's abuse and his death. The defendant's own children. In a forensic interview that was conducted by Major, and remember the dynamics of the forensic interview. At the time that law enforcement originally responds, on February 11th, they believe this may be an overdose of prednisone. There's bruising on Alexavier's body on the outside, but they don't know about all the trauma on the inside. In an abundance of caution, law enforcement sets up forensic interviews of the children. Major goes and stays with his dad, a dad who has no idea what's happening inside the home of the defendant. Brantley and Araya stay with the defendant's family. They are with separate families and think about what they report in those forensic interviews. Major says that this defendant kicks Alex a lot in his chest and in his face. That this defendant kicked Alex the last time Major saw Alex. That'd be the night before he died. That this defendant has choked Alex on multiple different occasions. That this defendant gets mad at Alex because Alex gets up at night for snacks. This defendant puts hot sauce on his food as a punishment. That this defendant stomps or steps on Alex's chest. Major was interviewed a second time, less than a month later, on March 2nd of 2023. During that forensic interview, Major talked about the purported stairway fall and what this defendant did after that purported fall down the stairs by bending Alex's leg until Alex cried out in pain, and the defendant told Alex to be quiet or she would bend it further. Major also talked about seeing this defendant choke Alex during that same encounter. Brantley was interviewed originally on February 12th. Brantley talked about Alex stealing, that this defendant got mad for the stealing and kicked Alex in the chest, that Alex whined and winced in pain. Brantley made a statement in that forensic interview about how this defendant in the past used a spoon to strike Alex. When he was asked if there's any choking in the house, he said, yes, my mom does it, and she does it to Alex. Both Major and Brantley independently say all of this happens when Derek is not home. And Brantley says, the evening before Alex passed, he was asleep upstairs. Brantley made statements in that forensic interview about green poisonous water. He made statements about guns upstairs, diamonds upstairs, and the spoon being upstairs. Those statements have been represented as untrustworthy just because of the nature and the content of what they contain. This is a 5-year-old child talking. Do not judge a statement of a 5-year-old child from the perspective of an adult. I like to take my kids to sporting events. When they're much younger, I would take them to Brewer games. When someone would ask me what happened at that Brewer game, I would talk about the pitching, who hit well, what the final score was, and how the Brewers played overall. The perspective of my daughters, who are much younger, would talk about what they got to eat. Did Dad buy licorice? Did we have ice cream? Did we go to the PlayStation inside the stadium? We had the exact same experience, but the perspectives that we had as an adult and as children were different. Brantley talked about green poisonous water. Remember the scene photographs? There was green water in the toilet. Brantley talked about his dad having guns. How many times in those videos that we are shown were there actual arguments about firearms in that house? It came up more than once. Brantley talked about diamonds being upstairs in that same area. It makes sense that jewelry and a gun or those type of items are all going to be stored in a safe area in the house. That's a 5-year-old child's perspective. That's what he's describing. Remember that. Brantley was interviewed a second time after Derek recorded Brantley. You saw Derek record Brantley. You saw the full recording. Derek actually asked open-ended questions. Tell me what you just said. What happened after that? What happened after that? Those are open-ended questions, the kind that you heard from Danielle on the stand that you should use when you're interviewing a child. Based on those open-ended questions, a second forensic interview is set up of Brantley. During this interview, Brantley said that this defendant pushed Alex down the stairs. But what's important about what he was saying is he's talking about a push down the stairs before death. He's not talking about the push down the stairs that happened resulting in the broken leg. He's talking about something that happened within the time frame right before Alex died, where this defendant was abusive of Alex. He says that Alex would get up at night for food, and he describes how this defendant pushed Alex down the stairs. Brantley says it happened the day before Alex died. Why is that important? Because when Brantley took the stand and talked about that fall, he said the exact same thing when he testified in this courtroom before all of you. That there was a push down the stairs the day before Alexavier died. You know the dynamics of where each one of these children lived in separate households. And you saw both independently testify to the vivid abuse they witnessed at the hands of this defendant. Major took the stand in the very same courtroom where his own mother is in the courtroom. Think about that from the perspective of both Major and Brantley. They came into the courtroom and they testified in the same room as their own mother about what she did to their own brother. Major said that the defendant would punch, hit, kick, and choke Alex. He said all of these things happened while Derek was at work. He described a specific instance of kicking in the kitchen where the defendant kicked Alex while Alex was on the ground, kicked him multiple times. He talked about another incident that happened in the living room where mom, quote, kicked Alex everywhere on his body. He talked about multiple instances of choking, including one that happened the day before Alex died, where the defendant was on top of Alex, straddling him. And he gave a really powerful and a really vivid description of Alex's response, his bodily response to being choked. He talked about how his arms and legs were flailing. Think about that. Think about that, because that is a natural response to someone choking and trying to fight off being choked. And he's telling you with his eyes what he saw this defendant do. He talked about how this defendant would punch Alex, and he demonstrated with his fists. He talked about how Alex would be treated differently with food. He'd be kept from eating. He only got crust from the pizza. He'd get hot sauce on his food. He was treated differently. He was made to sit on the floor if he didn't finish his food on time. Talked about how Alex would get up in the middle of the night. The defendant told you that Alex got up in the middle of the night. Brantley, who has not been living with Major, has been living with Derek, verified Major's account of events. He described this defendant assaulting Alex over and over. Talked about Alex being on the ground and the defendant kicking Alex in his chest. Brantley said this defendant would abuse Alex a lot, that she would routinely choke Alex. Alex's face would turn red and sometimes purple. This defendant would choke, kick, and hit Alex on more than 3 occasions. During this trial, he was asked about food for the first time. He says this defendant would put hot sauce on Alex's food. This defendant would add more hot sauce if Alex wouldn't eat the food with the hot sauce on it. Years passed between those original interviews in February of 2023. Major was now 12 years old when he took the stand. Brantley was 9. They have grown up. Their vocabulary has improved. They have more words to tell you what happened, and they use that vocabulary and those words to tell you what they've witnessed in their home with their own eyes at the hands of this defendant. Ladies and gentlemen, child abuse is a crime that happens behind closed doors. Perpetrators of child abuse rely on that fact. They rely on the fact that the public is shielded from their actions, that you can't see what happens in the home, that the victims of child abuse are people that they have relationships with, that the witnesses of the child in the home are people that they have relationships with. That provides perpetrators of child abuse like this defendant with protection. But this defendant's own children told you about this defendant's abuse of Alex. And if you're wondering why, and the state doesn't have to prove motive, there's a couple things for you to consider. This defendant suffered a traumatic brain injury by Alex's mother, Jenna Love, hitting her with a baseball bat. Alex's father, Derek, has repeatedly abused this defendant. Alex as a child, every time she looks at Alex, is a reminder of Jenna Love and being assaulted and having to take care of Jenna Love's son, and a reminder of Derek's domestic violence and having to take care of Derek's son. And if you still have doubt, and you shouldn't by now, you can consider this defendant's prior conduct and whether it establishes the identity of the person who abused and neglected Alexavier. You know that in 2011, Haley suffered a traumatic brain injury. Haley was admitted to the hospital with multiple skull fractures. According to this defendant, Haley suffered that traumatic brain injury from a fall downstairs. In 2013, Haley was admitted to the hospital yet again after living with this defendant and Dustin Barnes for a period of 6 months. In those preceding months, Haley went from the 80th percentile in weight to the 6th percentile in weight. She was losing hair. She had a fractured foot and potential fractures in her hands. Haley was not this defendant's child. There was another child the same age as Haley that lived in that house, and the two were treated different. Alex is not this defendant's child. There are children of a similar age to Alex in his home. According to those children, Alex was treated different. You can only use the evidence from 2011 and 2013 if the similarities from that evidence, and in this case, help you identify who the perpetrator of the abuse was. I want to talk a little bit about child neglect. Alex had over 100 absences from school in 2 years. In a little over the half year that he attended the first grade, he had 40 absences in 75 days. The principal of Alex's school testified about the harm that is caused to children when they don't attend school. It impacts their growth, it impacts their development, it impacts their functioning, it impacts their social skills. You also saw Alex's appearance at the time of his autopsy. He was extraordinarily thin. He was dehydrated. Conditions that were consistent with what the children described with terms of him eating or not being able to drink because if he drank, it would cause him to have to go to the bathroom. You know that Alex had a broken leg. You know that Alex wasn't taken for medical treatment for days after that broken leg. Derek deserves responsibility for that, but so does this defendant. There are many ways in which you can get a child to a medical facility without having to drive them there. There are many actions that this defendant could have sought to try and help Alex. And I want to go back to Alex's death. A person who intentionally administers a drug to a child to put that child to sleep has a responsibility to watch over that child. When you engage in that extraordinarily dangerous conduct, that's not an excuse for you to go to sleep and hope that everything turns out right the next morning so you can go on that date. But that's what this defendant did. Giving Alexavier drugs and then going to bed after he is knocked out and not watching over him contributed to his death. Because if there was action taken, monitoring to counteract the effects of those drugs, Alexavier could still be alive. In this trial, you get to consider this defendant's words and actions. She never disclosed the abuse to the children outside of one arguable 911 call to police, to friends, to family, except for one video that she sent to Laura Lee. And what were her instructions with the video that she sent to Laura Lee? Hold on to it in case I need it. Not help me, not help my children, not protect me or protect my children. Hold on to this in case I need it. You know that this defendant got rid of the SD cards. Special investigator or investigative Sergeant Amundsen saw those SD cards on February 11th, 2023. He didn't collect them that day, and I imagine he's kicking himself for it. This defendant had the password, the ability to log in, and when you log on to the account, it sends a notification to the email of that account. We saw the notification when Investigative Sergeant Amundsen logged in. And as he's logged in, the videos are being deleted. The holder of that account would get the notification and be able to sign in and delete those videos. This defendant was deleting those videos. You know that after the death of Alexavier, Derek was meeting with law enforcement, gave a statement to law enforcement, was cooperating with law enforcement. And this defendant's response to that was to tell him he should not do it. This defendant's words, her actions, show her guilt. Her lies about the shower establish her guilt. After I've been speaking to you for a while, I'm now going to talk about the law, the most exciting part. That was supposed to be funny, none of you laughed. Count one is first-degree intentional homicide. It has two elements. The defendant caused the death of Alex, and the defendant caused the death of Alex with the intent to kill. I want to talk about the intent to kill. Intent to kill includes language that the defendant's actions were practically certain to cause the result. You saw the brutal beating that Alexavier sustained at this defendant's hands. You saw the drugging and the amount of drugs in his system. There can be no conclusion, but each of those combined demonstrates that it's practically certain to take Alexavier's life. It is difficult to fathom a caretaker, someone who fills a parent-like role, extinguishing the life of a child. And for that reason, you have lesser included offenses to consider. You have the ability to consider whether or not the defendant's actions were intentional or utterly reckless. Make no mistake about it, it is the state's position that this death was intentional. The beating, the brutal beating, combined with the administration of a drug at that level, made it practically certain that Alexavier was going to die. Count 2, child neglect. One of the elements is a person responsible for the welfare of a child. A girlfriend to a parent is a person responsible for the welfare of a child because that parent is using or employing that person as a caretaker for their children. You have to find 3 acts of child neglect during that time frame, and you don't have to even agree on which 3 acts, as long as all of you agree that there were 3 acts of neglect. There's medical neglect, there's educational neglect, there's nutritional neglect in this case, supervisory neglect, and there's multiple forms of each. All you as a jury has to do is find 3 or agree that there were 3, and you don't even have to agree on which 3 constitute the 3. You do have to agree on the one that led to death. For that, the defendant had a responsibility to Alex to watch over him after giving him that drug, and she failed in that responsibility. I've talked about that already. Count 3, repeated acts resulting in death. Again, you have to find 3 acts, and you don't have to agree on all 3. The testimony of Major gives you 3. The testimony of Brantley gives you 3. Alexavier's body gives you more than 3. From that, it's easy to find 3 acts of child abuse that this defendant inflicted on Alexavier. Did the defendant cause bodily harm is the first element for each one of those acts. Bodily harm includes physical pain, injury, or impairment of physical condition. All Alexavier had to have was pain or impairment of his condition from this defendant's acts. That the defendant acted intentionally. Kicking someone is an intentional act. Punching someone is an intentional act. Hitting someone is an intentional act. And by God, choking a 6-year-old child is an intentional act. Did one of those acts cause the death of Alex? This is where you do have to agree. You have to agree on the act that caused his death. The testimony of the medical examiners give you 2 different ways. The abdominal injuries that Alexavier had were a substantial condition resulting in his death. That's what Dr. Quinton testified to. He listed as the #1 cause on his report. Impairment of his physical condition by administering a drug is another way of committing child abuse. It's an intentional act, it impairs his physical condition, and the administration of Xanax caused his death. Either one of those, as long as all 12 agree, is sufficient for finding and answering that question, yes. Dr. Endres said in her testimony that this defendant avoids responsibility. that this defendant projects blame on other people. You witnessed that through the defense testimony over 2 days. There was something that the defendant said twice during her testimony that all of you should agree with. This defendant told you twice that Alex was murdered. Alex was murdered. Alex was murdered by this defendant. This defendant does everything she can to avoid personal responsibility. Give her a lesson in personal responsibility and find her guilty.
All right, thank you, Mr. Torgerson. What I'd like to do is take a break, obviously this long, so we're going to take a 15-minute break. We'll start back up at 2 o'clock. I want to address one thing before we break up. Just to address the objection that the defense made, the argument was burden shifting. It was on the issue of did the defense present witnesses about Derek Pedrin specifically?
It was about a witness a possible witness that was referenced in opening that.
Can you pull the microphone a little bit closer? Sorry.
It was about a possible witness in opening that the state faulted Ms. Dikeman for failing to call. That's black letter burden shifting.
I don't think it's burden shifting at all. It was something that the defense said would happen that did not happen, and I was pointing that out.
I think pointing out something that's said at opening that doesn't happen during the trial doesn't necessarily, it can be burden shifting, but given that I don't think it shifted the burden overall. It was also in the context of talking about Mr. Pedrin's abuse. That's what I had the impression it was about. If it was, I'll just say this, it was harmless if at all. The burden is very much clearly stated, and then the instructions will be restated. One thing I should say that I usually read 160 before I do closings. I realized I hadn't read that. I will do 160 after I do closings, which actually talks about, about evidence. It doesn't talk about the burden per se, but we actually were talking about the burden all throughout the instructions. And it also goes on about returning a verdict in 515. So at this point in time, the court, I overruled the objection, moved forward, partially because I didn't want to make, a lot of times they're trying to avoid pointing out something that could become a problem. So in this case, I don't think it was. I don't think it was clearly burden shifting. So at worst, it was ambiguous. At best, it wasn't. So the court will go ahead and we'll get back at 2 o'clock. All right, everybody may be seated. Defense closing, go ahead.
You just like getting your fucking ass beat? Ladies and gentlemen, is there a more terrifying thing a father could say to a 6-year-old child? A child who depends on him for protection, a child who cannot defend himself. And so he naturally looks to his father and should be able to expect that he won't harm him. Pedrin's statement tells you something. Do you like getting beaten? Tells you that it happened before. It tells you it was going to happen again. Tragically, it was routine. And it tells you something else that is critically important in this case. It tells you that Derek Pedrin was not Alexavier's protector. He was his abuser. And that matters. That matters because this case is not just about what happened to Alexavier. It is about what law enforcement chose not to see. It is about what they refused to investigate. It is about how they locked on to Josie Dikeman from the very first hour and never honestly revisited their assumptions, even after the medical science, the facts, and their own forensic pathologist proved that major parts of their theory were wrong. From the very beginning of this case, back in 2023, the government has tried to give us all a headline. Mother murders stepson and stages scene. That is the government's headline. It is dramatic. It is sensational. It is horrific. And it triggers a powerful emotional response. It is exactly the type of accusation that can hit hard and cause people to stop thinking critically. But our law asks more of you than simply reacting to a headline. You must read the article. You must critically examine the evidence and separate emotion from proof and search for the truth. And when you do that, you'll see that the government has tried to give us all the wrong headline. What the headline should be is innocent woman charged, suspect at large. Ladies and gentlemen, this is a case about how innocent people get convicted of murder. And I want to put something right out in the open, just to say it. Usually when I go to sleep at night and hit the pillow, I'm out. I'm out for the night. But last night I didn't sleep at all. Because I'm terrified. I'm terrified that something I failed to do or say or failed to explain will end up with an innocent woman being convicted. And so all I ask of you is that when I inevitably fall short in giving you my thoughts on this case, that when you go back into the jury room, you draw upon your collective wisdom and the many, many notes you took throughout this trial. Now, this case comes down to three fundamental truths. The first truth is that this investigation was not a search for the truth. It was a defense of a premature conclusion. The second fundamental truth is that the medical science does not support murder. And the third fundamental truth about this case is that there are multiple reasonable explanations that are consistent with Josie's innocence. Overdose, Derek as the abuser, injuries not intended to cause death. And the list goes on. I would like to talk to you about some of those as we go forward. But I first would like to start where the law begins, the burden of proof. Proof beyond a reasonable doubt. And we've all heard that before. And what is the burden of proof? Well, the burden of proof was built on a hard lesson, which is that when the burden is too low, innocent people do get convicted. Because human beings, the courts are run by human beings. We are all human. We are fallible. We make mistakes. We make assumptions. We have biases. And the burden of proof is designed to protect against those very human errors. And that is why we have such a high burden. Because society concluded that it is unacceptable to convict innocent people for something they didn't do. So I'll talk briefly about what reasonable doubt is. But I'll first start with what it is not. What reasonable doubt is not that you think something probably happened. It is not enough that there is more evidence that you believe of guilt than there is of innocence. It is not even enough that you are firmly convinced, that you have a strong belief that something bad happened based on the evidence. That is not enough. The government must eliminate each and every reasonable hypothesis consistent with innocence, any reasonable explanation consistent with Josie's innocence. And we heard some of that in the trial testimony. We heard from Dr. Quinton that overdose is a very real possibility. It is squarely supported by the evidence. And if this was an accidental overdose, count one must fail. This is not an intentional homicide. And if it's an overdose, count three must fail. And that's just one example. And you'll hear more as we go forward. But it is important to know that you do not have to solve every mystery. You do not have to pick the explanation that you think is the most convincing. All you have to do is determine if there is one single reasonable doubt in this case. Just one. Now let's talk about the first truth in this case. That this case was not a search for the truth. It was focused on defending a conclusion from day one. A 911 call comes in, reporting the tragic death of a child. And even in that first moment, Josie raises the possibility of overdose. And so what do law enforcement do? By sheer happenstance, they arrive within minutes. And they immediately judge Josie guilty. Immediately, they conclude that she must have staged that scene. Immediately, they thought she must be covering for a horrible crime. Only a murderer would stage the scene. And what was their evidence at that point? Pill bottles around on the floor. They had no testing on those items. They formed a conclusion based on an assumption from day one and began defending that conclusion rather than trying to find out what actually happened. Now, let's talk about the investigation and the incredible failures that we saw because of a breakdown in the chain of command. Now, you saw from the testimony that there was no single person in charge of this investigation. And Lieutenant Williams, he agreed. This is not just an issue about flow charts and organizational dynamics. This is a critically important factor in any investigation this complex. There are hundreds of witnesses to interview, multiple competing inferences and explanations, medical science, forensic analysis, thousands of hours of video and audio and paper, hundreds of thousands of documents in this very case alone. And so it is critically important that you have one person in charge to assign tasks and to ensure that things do not fall through the cracks, important things. But that is not what we had here. There was testimony, again, that no one was truly in charge. And even Sergeant Amundsen, when he testified very reluctantly that he was in the lead. He was the last man standing. Now, there's an analogy that I think captures the concerns with this investigation. Imagine putting together a puzzle while throwing away every piece that doesn't immediately fit. You probably wouldn't end up with a complete picture. Now, let's talk about the behavior, the actions of what happened. Because an investigation should not just draw a conclusion and defend that conclusion. An investigation should actively try to disprove its own conclusion, just like the scientific method, to test all of the other possible reasons or possible explanations of what happened. But we did not see that in this investigation. And so we cannot be certain of its results. And a very early example of that, an investigation at the very beginning, it should expand. It should look at all the possibilities. It should not immediately narrow. But we saw how this investigation immediately narrowed when instead it should have broadened. And we see that in the DNA evidence, which you didn't hear anything about in the closing argument of the government's attorney. And why is that? Because the investigation into the DNA evidence and who touched the pill bottle and the cap was not designed to search for the truth. It was designed to prove that Josie had lied about staging the scene. How do we know that? Because they sent it in, but they only tested for Alexavier's DNA. And guess what? It was on there. That supports the idea that he got into something overnight. It doesn't support the staging theory. And so what did they do? Did they say, you know, that's unexpected. We should look into this? No, they immediately stopped and asked no more questions. They didn't test samples from the other adults that could have contributed to those items. They didn't test Derek Pedrin or Josie Dikeman or Karsten Jar. They simply said, oh no, this doesn't support our theory, so we're going to stop looking. That is the very first investigative decision that happened in this case. Even though the crime lab analyst specifically said, please send us more samples from individuals believed to be involved. They did not do that. Folks, this only required mailing in a DNA sample. And they didn't do that. If this were truly a search for the truth, why would they not submit comparison samples? Why would they not want to know who touched those bottles? Because what we were left with was uncertainty. And that uncertainty belongs to the government that has the burden. And investigators never tested the coach bag. And think about that. What would that tell us? If Alex's DNA on the coach bag was on the coach bag, that would show that perhaps, that would show that he gotten into something. But they didn't do that. And so we don't know. We are left with incomplete evidence that we cannot rely upon. And there were pill fragments on the pillow that were never tested. And Dr. Quinton acknowledged this would be important contextual information, as well as Dr. Christensen, that would help us understand, was this an accidental overdose? They never tested. So here we have the centerpiece of the state's case, the state's homicide case against Josie Dikeman, and they never even fully tested it. Why is that? They want us to believe them. They say, believe us. We believe it, so you should too. But they don't have any facts to prove that because they didn't look for them, because they were afraid that the answer would not point to Josie's guilt. Again, they were not testing for their own theory being wrong. They were not truly searching for the truth. Contradictory evidence was ignored. And confirmation bias took hold of the investigation. And just briefly on confirmation bias, we all know what that is, even if we don't always call it that. It is what happens when everyone watches the same play in sports, and the Packers fans say, obvious pass interference, and the Vikings fans say, no, that was clean. And it's particularly powerful, for instance, in politics, when we seek out information and then have algorithms just feeding us back what we want to hear. And so we start filtering all of the evidence that comes in to be consistent with what we already believe. And to be clear, this is not about bad intentions or makes you a bad person. This is a universal human trait that we all have, and that is so powerful, not because it is overt or obvious, it is so powerful because it is subconscious. But it is powerful nonetheless, and that is impossible for any of us to deny. And police are not immune. Medical personnel are not immune. Children are not immune. We all seek to conform evidence to our existing beliefs. And it takes a lot of effort to avoid that pitfall. So again, let's talk about the tunnel vision on Josie. Investigators admitted Derek Pedrin was a suspect. Sergeant Amundsen said he is still a suspect to this day. That is the very definition of reasonable doubt. And there's more. 10 days into the investigation, investigators were already working with Derek Pedrin to defense-proof the case. Now, you heard Sergeant Amundsen come in and testify under oath. The first time that conversation happened, that was in September after Josie was already charged and arrested. Matter of fact, that's not true. It was 10 days after Alexavier had died. And I think that demonstrates one of the fundamental failures of this investigation, which is that none of the investigators had read all the reports. And the reason why Sergeant Amundsen didn't really know what happened in that meeting in September, which was a meeting that was never disclosed to the defense, no report was made of it. We only learned of it because we physically laid eyes on every bit of video evidence that was in this case, and we discovered this. We said, okay, here's a meeting with a key witness in the case, talking about problems in the case, talking about how the Xanax issue, and talking about Derek's phone. In the very beginning of that meeting, the investigators asked Derek, this was in September, do you still have that phone that we were interested in looking into? He said yes. But then, a little while later in that same conversation, they asked him again, can we see your phone? He said, phone, what are you talking about? It's broken. I don't have that phone. And they never even asked what he meant by that, not once. They never seized Derek Pedrin's phone at all, this entire investigation. And let's draw the contrast between that behavior and that of Josie's. You saw Josie's interview with Lieutenant Williams at the very beginning of this case when this had just happened. And Josie handed over the phone willingly. Now, of course, it is true that investigators could have seized that phone without question. And maybe Josie knew that. Maybe not. But what they couldn't have done is compel her passcode. And Josie gave them her passcode without any problem. And that unlocked her life for investigators to inspect. Guess who didn't do that? Derek Pedrin. And think about phones, just for a moment. A phone is no longer this rotary dial, object that we had in our house to communicate people across long distances. No, it is now essentially an alter ego. There is no single belonging that any of us possess that gives more insight into what we are doing with our lives, where we physically are located at any given time, what we're searching for, who we're communicating with, what we are communicating about. This gives police a roadmap into Josie's life. And because she had nothing to hide, she gave it to them. Can we conclude the same thing about Derek Pedrin? That is up to you to decide. So again, we see the investigation immediately focusing only on Josie and not testing its own theories. Now, again, Derek Pedrin admitted to Xanax bringing it into the house. But that wasn't what he said at first. He had to be caught lying in that very first instance. Because he first said that it came from Josie. It came from Josie's mom. It came from her prescription. And that was not true. And then he said it was from Ted Colkine. She got it from Ted Colkine. Investigators ran down that lead. Turns out that wasn't true. So finally, he admitted to being the source of this substance that we know could very well have killed Alexavier. But they never fully investigated. They never investigated his supplier. They never investigated drug transactions, and they never followed up on any of this evidence. There was a critical text about scripts on February 9 of 2023, one day before the evening into Alexavier's last day. And they never investigated that. We only found out about what was going on when Mr. Pedrin was up on the stand and Attorney Zachar asked him about it. That was the first time. Investigators apparently never asked. So we had to do that in open court in front of everyone and find out what the answer is. Let's talk about Derek Pedrin again for a moment. Investigators knew he had a lengthy history of violence, 7 criminal convictions, a serial strangler of women, Josie being first and foremost. Threats to kill Josie. He put her head through the wall several times. There were no contact provisions, but that was just a sheet of paper. And we also saw that there is evidence of child abuse. You saw that video. It was heart-wrenching. Do you like getting your ass beat? That represents rage, intimidation, and violence and abuse. And when Mr. Pedrin was asked about that particular incident, the question was, you were out of control, right? You would agree. You were out of control. His answer? I wasn't out of control. I was just angry. Does that match up? If any of us were walking down the street and saw somebody behaving that way towards a child, would we say, no need to worry. He's not out of control. He's just angry. Well, apparently Sergeant Amundsen agreed with that as he testified. Now, there's another thing. And here is a very telling exchange. When Mr. Pedrin was asked, have you ever punched or kicked the children? His answer, I don't think so. Is there a parent in this world who cannot simply answer that question with a no? That would be a parent who has done that more times than he is willing to admit. And so we have repeated lies from a suspect in this own investigation. Lied about the Xanax. And let's just ask if he's willing, and he lied about his alcohol use. Even though he got arrested months earlier from his testimony while he was intoxicated. I guess we have to believe that he forgot about that, but the truth is much likely different. And so if Mr. Pedrin is willing to lie about some of these the smallest things that don't matter in a criminal trial, are we really to believe that he wouldn't be willing to lie about what's most important to him? His own responsibility for Alexavier's death? That is a question that you will have to resolve. But the importance of this, the point is that the government's investigation, it created the uncertainty in this case. And they own that uncertainty. They created it, and they took on the highest burden in the law when they filed these charges. And they don't just get to come in here and throw out different possibilities of what might have happened. They have to provide precise proof of what happened in that house and what caused Alexavier's death. And so again, we saw no single investigator reviewing any of the case file, key interviews without police reports, and again, I must say one more thing about this meeting that happened in September that was not disclosed in any report. In a search for the truth, investigators document important witness context when they're talking about problems in the case. They're talking about issues in the case. They write reports. I mean, they wrote a report about some random person who evidently didn't know Josie and said something about how she wouldn't let her look after her dog. But they didn't write a report with one of their key witnesses, who apparently is still a suspect? Why? Because if you're searching for the truth, you document these contacts. But if you're defending a conclusion, inconvenient facts have a way of leaving no paper trail. So we see how evidence portraying Derek negatively was minimized or ignored. Evidence portraying Josie negatively was amplified and emphasized. Investigators never failed to follow up on statements that Derek treated Alex poorly. And these irrelevant comments were included. And we'll get to this later, but there was also a key piece of evidence in this trial that you heard, which was the 911 call in November of 2022, when Derek Pedrin had viciously assaulted Josie by repeatedly punching her in the throat and strangling her because she cooked the beef, the ground beef, for the kids. That was his ground beef. And so that's what he does when you cook his ground beef for the kids. And she told you that in the 911 call, that she had no reason to know would show up in a homicide trial 4 years later. But what does that tell you? It tells you that she said he did the same thing to his 6-year-old, to Alex, and that he was teaching Alex to lie. That was in that call. That is a snapshot of what is actually happening in real time, before anybody knew it would become relevant in this trial. That is evidence you don't have to ignore. So let's move forward to some of the most dramatic, incredible testimony I've seen in a trial. when Lieutenant Williams was asked about what is the state's theory? Why would Josie do this? When she was looking forward to a date, she was taking selfies with Brantley, she was texting with Raphael, she was seemingly looking forward to a future with someone other than Derek. Why would she do that? And Lieutenant Williams' answer was, if you're saying she killed him that night, I have no idea. Once again, that is the very definition of reasonable doubt. If he doesn't know, how can we? And then you also heard from Sergeant Amundsen, the lead investigator, who apparently hasn't read all the reports, looked at the transcripts, or watched all the videos. He testified that that conversation about thinking like defense lawyers happened in September. That was wrong. It happened February 21. And he testified as well. What is your theory? Why would you do this? How did this happen? And he said the working theory is that Josie must have murdered Alex because he wouldn't let her go to sleep. She wanted to go on a date the next day, so she murdered a child. And that's their working theory. Like my working drafts, which go through 8 different versions before I finalize them. So maybe if we have a trial in 2 weeks, the working theory would change once again, because they do not know. They are required, beyond a reasonable doubt, to prove exactly what happened, not to provide us with a working theory. So if the supposed lead investigators can explain to us what happened, how can we know? And why don't they know? It's because the evidence in this case never supported the murder theory. The evidence kept pointing back towards overdose, towards Derek, towards uncertainty. But that overdose evidence was ignored. You heard from Dr. Quinn. He could not determine the exact cause of death, and he could not rule out overdose. And he said that Xanax's role in this was crucial. What does that mean? That means that overdose is not some far-fetched speculative theory. It is reasonable. It is medically supported. It is consistent with the toxicology. And it is so critically important to understand that if this was an overdose, intentional homicide is not proven. Count 1 is not proven. Count 3 is not proven. And that is enough for reasonable doubt just in and of itself. But then we have an example from the medical examiner, from Ms. Lubinsky, who, I guess in Wisconsin, well, I know in Wisconsin, we don't have medical doctors who serve as medical examiners. I guess that's unique to us. But it seemed like Ms. Lubinsky was much more of a police officer than a medical professional, because her entry into the case essentially was an attempt to overrule the pathologist who said that this was homicide due to the actions of some other person. But instead, she wrote that there was homicidal violence and that Alexavier died from homicidal assault. Those were her words, not Dr. Quinton. He told you that. Those weren't his words. He wouldn't have used them. And so what does that tell us? Well, what it tells us, as well as Ms. Lubinsky's testimony, about how the mindset had taken such strong hold that this was only about proving Josie guilty. It was not about exploring what happened. And that is why Ms. Lubinsky came in and she told us all that there were brown bananas on the fruit stand in their house. And we saw the photo. The brown bananas were next to fresh fruit and other snacks that the kids could get freely. And frankly, if brown bananas are criminal neglect, then you're going to have to lock me up too, because how many of us have not let bananas overripen in our kitchen? But the point is that bananas are not evidence of criminal neglect. They are evidence of how confirmation bias was so powerful in this investigation. And look, we know why that was. We know why. It was because Josie was never going to be able to move past her earlier convictions in 2001 and 2011 and 2013. And I will say, my biggest fear in this case is that you will not be able to look past this evidence for what it is. It is the state attempting to distract you, to overwhelm you, to provoke anger, to distract you from anything but the lack of evidence in this case. We never tried to hide this from you. We told you this was coming. But if the state had the facts to prove its case, they wouldn't have to rely on convictions that go back to up to 15 years ago. And the state is trying, not subtly, to use this prior conviction as evidence of current guilt. They're trying to say she was an abuser then and she's an abuser now. That is what they're trying to get you to conclude. But the evidence doesn't support that. The 2011 evidence did not conclude that she was abusive. This was an incident where a young child fell down the stairs. And this similarity, I think, explains why they believe that they can use that to say that she must have done something wrong here. But the facts are much different. In that case, Josie was a 19-year-old addict, and she did not care about her responsibility. She was neglectful, and a child was injured falling down the stairs at her apartment. Now, that was investigated at the time, and investigator Tony DeLapp, the officer who investigated this, walked through the house and noted no inconsistent information about what she had reported. Josie took the child immediately into the hospital. And there was no medical certainty in that case. 4 doctors agreed that this was consistent with the explanation. And there was not one doctor who was willing to say that this was abuse. And there's another important aspect of that. There was evidence that was destroyed as part of that. And the instruction says that you can conclude, you can draw the inference that this would have been favorable. But the point is that abuse was not established at all in that case. And there was no conviction. But there was another concerning circumstance with Haley in 2013. To be sure, there were some fractures, and there were some other conditions having to do with malnutrition, vitamin D deficiencies, other physical ailments that are dangerous for a child if they're not treated. And that was investigated thoroughly. And it was believed that as to the physiological conditions, that she had celiac. And celiac basically explained all of these conditions. It's basically a disorder that prevents absorbing proper nutrients. And that explains vitamin D deficiency. That explains some of the other findings. This was a coherent explanation from the medical science of what would lead to some of these conditions. But then you did have these concerning injuries. But what did they find out? They investigated everybody in that household. They interviewed them. Not one of them said that Josie was abusive towards the child. Not one. In fact, her partner at the time, who was the other caregiver who was in that household all the time, he had no job. Josie didn't work full time, but she was picking up shifts when she could. But her partner, Dustin Barnes, told investigators she never hurt the children. That was what's called a statement against interest, because he was the only potential source of those injuries. And once again, there was no established abuse by Josie in that case. The conviction was for neglect, not abuse, and that is important. Now again, the government wants you to conclude that Josie was an abuser then. She was secretly an abuser, and now she's an abuser now. But you cannot use that reasoning. The instruction tells you that you cannot use that evidence to say that this is what happened. And again, if they had the facts to support their case, they wouldn't have to go lean so heavily on an older situation that doesn't even prove what they say it does. And just one quick point on that, which is that most people don't know what actually happens in criminal cases. All people usually know is what is in the criminal complaint. And that is a document written by prosecutors that has all the bad information that makes you look guilty, makes you look the worst. But people don't have access to the police reports. They don't have access to the medical experts, any of the forensic analysis. They don't really know the facts. And so when somebody has a past, particularly in a very troubling case, people are inclined to believe the worst because they just don't know the details.
Judge, I'm going to object. We stipulated to these facts, and we're now arguing the facts that we stipulated to?
I assume he's talking about the stipulated facts.
Yes.
Can
I'll
talk
move on.
about the
I'll
stipulated
move on.
facts.
So again, this is evidence meant to insinuate that Josie is secretly abuser without evidence. And there's a saying that where there's smoke, there's fire. And that is true. As far as I know, I don't know anything that produces smoke other than fire. But what looks like smoke is not always smoke. And in this case, what you're seeing is the massive cloud of dust that they are kicking up to distract you, to overwhelm you, to inflame you, to do anything other than look at the evidence in this case, or lack thereof. Now, the neglect case was very serious. It was wrong, but it was not abuse. And it does not explain what happened in this case. Well, what it does explain is how the medical providers were so quick to conclude that Alexavier had been abused in the femur fracture incident. And I won't dwell too much on that because the government's lawyer didn't talk about it too much. But just to be clear about that, the medical expert who looked at this femur fracture, who was most qualified to make an opinion about it, he said that this was 100% not abuse. Doctors don't speak in such certain terms unless they know something is true. And that was true. And Dr. Peterson knew that. And that was why he was so certain. And these other concerning conditions that I think the nurse was reasonably concerned about, and Dr. Glowacki, who you heard from, reasonably concerned about, those were found out to be not fractures, those were developmental conditions. But they look like fractures on an x-ray. And so the providers were concerned, reasonably. But the facts turned out not to support their concerns. And again, the only qualified expert that we heard from says that that was not abuse. And it is reasonable to believe him. But we saw through that femur fracture incident how suspicion immediately became conclusions. And that is the problem in cases like this, because we're talking about very difficult subjects, and it's hard not to get very angry about this. But anger clouds our judgment, and it clouds our ability to critically examine the evidence. And that's what we're here to do. So, touching once more on the second point, which is that the medical science does not prove murder in this case. In fact, it suggests otherwise. Overdose as a possible cause of death. Injuries that were not inevitably going to cause death. Injuries that do not reflect an intent to kill. That's all testimony that you heard from the medical experts. You heard that there was no fatal head trauma, no strangulation, and the blood loss was not a fatal amount. And you heard that alprazolam was crucial to the finding of the cause of death. None of the experts qualified could conclude that there was an intent for Alexavier to die. There was toxicology, again, showing highly elevated levels of alprazolam. This is not disputed. That was enough to kill an adult and certainly enough to cause a child's death. But here's the other point that's very important, is that this was a gradual process. And that reflects not a sudden, violent, homicidal rage. That is a gradual process, and sadly, it's consistent with overdose in this case. And the blood loss numbers, again, not sufficient to cause death. Those were not injuries that were inevitably going to lead to death. You had effectively 1/15 of the total amount of blood volume lost when you have to reach approximately 33% to start going into shock. And so these were awful, but they were not the types of injuries that would inevitably lead to someone dying. So again, the medical science contradicts the state's murder theory, and it points toward overdose. So I'll move on to a very important issue in this case before getting to the elements, which is the witnesses that you heard from and determining their credibility. You have Derek, Lorley, Major, Brantley, and children's statements filtered through adults. And you heard the statement, do you like getting your ass beat, whether you punched or kicked the children? I don't think so. Derek testified that he couldn't control his violence. So let's talk about Derek Pedrin's credibility. We've heard about all of the violence. Indisputably, he was deceptive throughout the investigation. He was shown to be manipulative, chronic liar, an alcoholic addict. And there was this sham marriage with Laura Lee, which we heard about from Misty Craig. And he lied about the timeline. We'll get to that. The timeline of when he got home that night, the night before Alexavier died. But let's just take some basic impressions from that testimony, because there were so many lies, it was very difficult to categorize and catalog them. But here's a figure that I think tells you all you need to know. When he was asked questions on his direct, questions that were designed to make Josie look bad, he was very certain. He was certain of his answers. When asked questions that would have made Josie look good in any way, he testified, I don't recall, 130 times or more. If you're telling the truth, you do not have to remember what you told other people. And you experience this, having to go in and out. Well, Pedrin had to constantly be reminded of what he had said on a video recording or an audio recording or something else, just to remind him, yes, that's what you said. You remember that? Again, if you tell the truth, you don't have to remember what you said. And then we had Misty Craig, who testified very reluctantly. I don't know about you, but she looked like another victim of Derek Pedrin. Well, in fact, she testified that she was, because this was the Derek Pedrin who was the abusive thug staring at her from the gallery. And she testified reluctantly, but she acknowledged that Derek said that he would cut her fucking head off and send it to her mother if she testified about the trial. And he said that he fucked up by telling her about the marriage to Laura Lee being related to this very trial. And then we had Justin Bolito. Thank God for Justin Bolito, the Good Samaritan that was watching this trial on TV like many others are. And he was so astounded and outraged by Pedrin's lies, open lies on the stand, that he reached out to us to set the record straight. He did not want to get involved in this. That is the last thing he wanted to get involved. But he was so troubled by the lies about Derek claiming he never used Xanax that he put himself into this, understanding that he could be put through the ringer. And boy, that is true. You saw the government's lawyer go up and just trash him and berate him with accusations that, let's put it this way, must have come from Pedrin without verification. That's all I'll say about that. But what the government lawyer didn't attack was Justin's testimony about Derek Pedrin using Xanax. Never attacked the veracity of that. Apparently, according to the prosecution, this young man was engaged in some big grudge against Pedrin for terminating his employment at the car wash in some sort of epic bid to regain his minimum wage employment at ShipShape. Is that realistically something that people would want to do, to insert themselves into a trial like this because they want to get their job back for the work under Derek Pedrin? There's a law school saying that if you don't have the facts, you pound the law. And if you don't have the law, you pound the facts. And if you don't have either, you pound the table. We saw a lot of table pounding in this trial, did we not? Now, again, if Derek Pedrin is willing to lie about these things, what makes us think that he wouldn't lie about his responsibility for Alexavier's death? You have to rule out beyond a reasonable doubt that Pedrin was the source of the Xanax. He admitted it. You have to rule out that Pedrin was the source of the injuries. We know that they could have occurred at the time when Derek was alone with Alexavier. We know that. And we know that Derek lied on the stand. Now, a reasonable doubt is a doubt that would cause you to pause or to hesitate when called upon to act in the most important affairs of life. And so what are the most important affairs of life that we all go through at some point? Whether to choose a partner, where to live, educational decisions, financial decisions, medical decisions, buying a house. Well, forget buying a house. Would anyone buy a used car from Derek Pedrin? And how about Brantley and Major? Their testimony fell well below reasonable doubt. But the government is not trying to sell us all a used car, sell you a used car. They're trying to sell you someone's freedom. That is why this is so serious and important, that this is taken, that is analyzed carefully, cautiously. So let's talk about the children's testimony. There's not a question about whether those children are sympathetic. Of course they are. But the question is reliability. The question is whether we can rely on their testimony in a trial for first-degree intentional homicide. The state must prove beyond a reasonable doubt that these children weren't coached. The state must also prove beyond a reasonable doubt that they did not lie under oath repeatedly. And they also must prove beyond a reasonable doubt that these children were so consistent, so credible, that their testimony can be relied on in this very homicide trial. What did we hear from the children? Again, the same habit of answering certain questions with confidence that made Josie look bad. But anything that made her look good in any way was met with a, I don't know. Now, this is something that I don't know if everyone caught when Brantley was testifying. Well, she was calling Josie, Mom Josie a lot. That was the name that he used instead of Mom. He said, Josie did this, Josie did that. But at one point, he answered, our mom. And then he immediately corrected himself. He corrected his own testimony and said, Josie. Now ask yourselves, does that sound natural, or is that something he was taught to say? And he apologized. He apologized to Pedrin in the middle of his testimony. And he was asked about that when he came back onto the stand. And he said he apologized to his dad for lying. So he admitted he lied on the stand. But what did he say that he apologized to his dad about? He apologized to his dad for not telling the jury, for not telling you that his dad was an alcoholic, basically, that he used alcohol. That was what he said. I'm sorry, Dad, I didn't tell him that you used alcohol. Now ask yourself, does that make sense? Do you think that he was apologizing for making his dad look good in the eyes of the jury? Or is it that he let slip something he was told not to say? When you have competing inferences and competing doubts, the jury instruction tells you very clearly that you must resolve every reasonable doubt in favor of Josie. And that is the rule that you will need to apply when you're in the jury room. And again, bringing it back to that 2022 911 call, where Josie reported this assault from Pedrin regarding the ground beef. And she said, Derek repeatedly punched her in the throat and strangled her, and that he did the same thing to Alex, and that he was teaching his son to lie. That is as reliable as you can get. That occurred at the time, not in preparation for this trial. And that's important, and you can consider that. And so let's talk about Brantley's testimony about the femur injury or the supposed kick down the stairs. So he says, apparently he was not talking about what caused the fracture, that this happened after Alexavier had broken his leg. And you must ask, is that consistent at all with the evidence? Now, there was no certainty of the exact day, and we can't rely on his dates, but let's just look at the evidence that we have, the objective evidence about that injury. There was a follow-up appointment with Gunderson, where he was found to be healing well. Dr. Golacki checked in, make sure that happened, and Josie took him to the follow-up appointment, and he was doing well. And then Sarah Wagner-Barton, the CPS worker, she did a home visit. She came through the house. Now, first she talked to the medical staff, and the medical staff had no concerns about Josie. And she also found that the kids were in good spirits and that she found no immediate safety concerns. But there was another little detail in that report of her talking with Alex and the family at Gunderson, where she said that Alex did tell her that Dad would spank. Well, and moving on, Ms. Wagner-Barton then went to do the site visit at the house, and she went through and she saw that the kids were being well cared for. They had all of their basic needs met. She had no concerns. Alex was doing well. He was proud of his cast. He was healing well. And that tells you that he was still healing well. He had not re-injured his femur. And then we do have the autopsy report. And there was no evidence that his femur injury had been aggravated. So the objective evidence contradicts this idea that Josie kicked this child down the staircase. And we saw that staircase. That thing was a death trap. And just to reiterate, the staircase condition was dangerous, but Josie was a renter. Shame on that landlord for allowing them to live in that condition. A tenant cannot be expected to just install railings or put walls alongside a staircase, finish a basement. That is not within their capacity. And so that is something that cannot be held against Josie. Now let's talk about Major Hellerud and his testimony. And the issue there is that you saw his testimony evolved as contrary facts got in the way. Reliable memories do not shift every time they are tested. And again, if you're telling the truth, you don't have to remember what happened. So you had the changing bedroom account, where Major's story changed as the facts developed. First, he saw this attack supposedly in Josie's bedroom from his bedroom into hers. But then he was confronted with the fact that there was a curtain up. And so he said the curtain wasn't always there, or it wasn't always up. And then when he testified at trial, it became he actually walked into the room. How can we know? None of those all cannot be true. And you can disregard that testimony because you have to determine whether it is precise proof that you can rely upon. And then you had this implausible testimony where Major said that Alex soiled himself because his mom would have let him go to the bathroom. Now, does that make sense that Josie would make a child soil himself so that she would just then have to clean up herself? That makes no sense. And then you saw the delayed appearance of this other serious allegation about the bending of the leg back while choking, which is how he mimicked it in the interview. And this was not mentioned in the first interview, but it appeared only after he had discussions with family and reappeared. But then he testified at trial to the opposite facts, that somehow this was a bending backwards. And this was a completely implausible mechanism for injury. So this was implausible, and it changed over time. And we all know that we show that the evidence suggests that the family discussed the case with Major. And there were concerns about coaching. And so the pattern was, Major remembered dramatic accusations, but when he was confronted with inconsistencies and prior statements and specifics, his response became, I don't remember. Again, how many times did he not remember? 137 times. He remembered the accusations, but not the contradictions. And the law requires testimony that is so consistent, so credible, that no innocent explanation could be true. So, does that mean you should not rely on anything the children say? Well, think about the example of a big pot of stew that you're making for the family. And somehow a big piece of rotten meat goes into that stew. Would you still keep the stew? Would you eat it? Or would you throw it away and start again? That is why you cannot rely on these statements as precise proof of the allegations in this case. We know the state itself is uncertain. We heard that from the lead investigators. But we also know because of the charges in this case. We see how the government added charges in the very middle of the case. That's why you have a new option here for reckless homicide. Because the state is trying to throw everything that they can against the wall and see what is going to stick. They need something to stick. But let's talk about the first count, intentional homicide. The state must have precise proof of causation. And if overdose is an explanation, there is no causation. And if injury is insufficient to cause death, that is not causation. So what do we not have here? We have no motive, we have no eyewitness, and there's no DNA tie, and there's medical uncertainty, and no coherent explanation. Why would Josie suddenly become a murderer while texting with Laura Lee and phone calls with Laura Lee and texts with Raphael, planning the date next morning with children? And let's talk about the timeline of that evening, the day before, February 10. Derek Pedrin arrived home at 5:30. How do we know that? Not because he told us. He said he got home at 6:30. But then we found out because we had the surveillance evidence to prove that he had left the Walmart at 5:30. And why would he lie about when he arrived at the house? He thought he would get away with misleading you. And we wouldn't have found out if we hadn't looked at the footage. Perhaps the government hadn't looked at the footage. But if he's lying about the timeline, then we have to wonder, is he lying because he thinks he'll never face accountability? And we know that Alex was awake at the time Derek was around. This was something that Major certainly testified to as well. But let's just get to one detail that I think is very important here. Pedrin testified that he had changed Alexavier's pants. But there would be no...
That mischaracterizes the testimony. Mr. Pedrin never testified that he changed. That came from the defendant.
Forgive me. There was testimony to that effect. Thank you. But there would be no reason to do that if he hadn't soiled himself. So again, we know that Alexavier was up at some point, and we know that he was asleep during the welfare check. And we know from the medical experts that that would be consistent with either potentially a concussion, mild concussion, or mild alprazolam intoxication. And so that is certainly consistent with the timeline. And we know that Pedrin was downstairs near him at that time, and that Derek had Xanax access. And so we know that Josie was texting about going on a date, and she slept from 3 to 9. Is that consistent with someone who knew she had just murdered a child? And again, her behavior in the morning, it was normal. Normal texts, ordinary plans. And then a shocking discovery and CPR attempts. Immediately raising overdose as a concern. Panic. And is this consistent with somebody who had just brutally murdered a child? Now, I remember we watched the interview with Josie with Lieutenant Williams. We all watched that together in the trial. And I remember watching that for the first time. And what I saw was a woman who was in shock. She was self-soothing. She appeared to be in disbelief and in grief. And it felt real to me on a physical level. This did not seem like a woman who expected for this to happen. She did not look like a woman who had just murdered a child. And so the reality of the home was that Derek dominated that environment with fear, intimidation, violence, drug use, children cowering in closets. And we have evidence of Josie's relationship with Alexavier. She communicated with the school regularly. She wanted to make sure that he was able to celebrate his birthday because he had a summer birthday, and he didn't want him to feel left out from the other kids who could celebrate their birthdays. She wrote to the teacher to make sure that Alexavier, she was concerned he was getting bullied. And so she wanted to make sure that Alexavier is not being bullied. Is that a woman who had callous disregard for this child's safety? Is that something, if you had just this murderous rage for this child, that you would do something like that? She wanted to make sure that his winter gloves fit properly, that he had water, that he had toys, that he had Happy Meals, having him sleep next to her in bed, taking him to doctor visits, making sure that he had badger care so that he could have dental care, when his dad had simply just tried to take a cap and shove it back into his mouth. And then we saw the Walmart video where Josie made sure that his sister went and got him a sucker. She wanted Alex to have a sucker too, so he didn't feel left out. She cared for Alex, like her own son. And again, does this seem like someone who had hidden homicidal rage for a child? This death was tragic, but it was not intentional. So, count 2, we see a contradictory theory where either she intentionally or recklessly killed him, but if you don't believe that, then she negligently caused his death. And you must find 3 separate acts of criminal neglect. Not just careless or something that could have been done differently. Neglect, criminal neglect, and causation. And to prove causation on count 2, you have to believe, the government has to prove beyond a reasonable doubt that Josie knew where Derek had put the Xanax in that household. Now, there is no proof that Josie knew there was still Xanax in that house. Derek was connected to the drugs, but there is no proof that she controlled the Xanax or even knew where it was. Now, Derek was an addict facing arrest. The simplest assumption or conclusion is that he either took it or flushed it. She would not know what he would have done with it while she was dealing with Sergeant Kernine. You cannot negligently fail to secure something you don't know is there. And if Derek caused the injuries were not obviously fatal to somebody who would observe Alexavier. There was no proof that Josie knew that, tragically, abuse had been normalized inside this home. Now, hindsight cannot replace proof. And this is an attempt to get the jury to reach a compromise verdict. If you don't believe the other theories, then you can settle on this one. But the law doesn't permit compromise when the evidence does not support chronic criminal neglect. And so let's go to count 3, repeated abuse and abuse causing death, that Josie failed to prevent abuse or caused abuse. Now, the major failures of this count are that, again, overdose is not ruled out. Injuries not proven to be fatal. And Derek, as the source of those injuries, not ruled out. And in terms of the failure to prevent any of that, they have to show a capability to intervene or a capability of doing something that would have prevented future harm. Now, let's talk about the bathroom incident. Derek goes into the bathroom with Alexavier and closes the door and locks it. She thinks he heard Alexavier, but she doesn't know exactly what happened. What is she supposed to do? Kick down the door? Physically overpower this person who has abused her repeatedly? Or call police at that moment? Calling police has never worked before. Calling the police would not protect her or Alex because Derek would get out every single time and the beatings would only increase. And again, remember that 911 call where she did report Derek hurting Alex and teaching him to lie? What happened after that? He got out and he immediately battered her again. Calling the police would not have caused or prevented, or would not have prevented future harm. We know that restraining orders wouldn't stop him. Nothing would stop him. So, before I sit down, I want to share some final thoughts. Because when I sit down after this, the government's lawyer has the last word because the government has the burden of proof here. So I just want to say thank you for sitting through what has been a painful trial. We could not do this without you. But you are doing it, and you are doing it the right way. And this case is heartbreaking. A young child died under horrific circumstances. Alexavier should have had a future. He should have had an opportunity to become something other than his father. And sadly, that opportunity was taken from him. And if I were sitting where you're sitting right now, I would want to punish someone for what happened to Alexavier. I would want that. Anyone with a conscience would want that. But the person who deserves that punishment is not on trial today. And I ask you not to convict Josie for her abuser's crime. Because the law requires justice. And justice is not vengeance. Vengeance is easy. Vengeance says a terrible thing happened and somebody must pay for it, even if the proof is uncertain. Justice is much, much harder. Justice requires discipline. Justice requires understanding when there's no uncertainty, even when it's emotionally unsatisfying. Justice requires understanding that sometimes the evidence doesn't provide a neat, complete answer. But does it achieve justice to rely on an investigation that searched only for evidence of Josie's guilt? Does it achieve justice when the medical science does not support the government's murder theory or its allegations of count 3? And does it achieve justice when there remain multiple reasonable explanations that are consistent with Josie's innocence? It is up to you alone as jurors to determine that. Now, your duty is not to the defense, not to the prosecution, not to public opinion, emotion, or sympathy. Your duty is to the law and to your own conscience. And to be able to walk out of this courtroom without ever having to wonder whether you may have convicted an innocent person. And if you have that doubt, then you have your answer, not guilty on all counts. Thank you.
Thank you.
Do you want me to go, Your Honor, or do you want me to?
Do we need a break for 5-10 minutes, or do you want to go ahead? Like everybody's ready to go ahead? Why don't you go ahead?
Ladies and gentlemen, believe it or not, my favorite jury instruction is the burden of proof, because it says exactly what your job is. Your job is not to search for doubt. Your job is to search for the truth. What you just heard was the smoke show continue that Josie started, the defendant started with her testimony. Look at all these other things, but how much of what the defense argued focused on the 2 days involving Alexavier's death? Heck, how many times did you hear the name Alex or Alexavier during their comments? They brought up the 2011 and 2013 other acts as if that was the entirety of what the state relied on. The state's argument regarding those was less than 5 minutes, and the state's argument regarding those told you exactly what the law says on how to use it. They're the ones that brought up using it improperly. I want to talk first about the accusation about the investigation in this case, and that there was tunnel vision associated with this defendant, because nothing could be further from the truth. The defense gave the example of a puzzle that is missing pieces. There was a puzzle with missing pieces in this case, but it was the defendant that was taking those pieces away from the. When they responded that day, they were first responders trying to save Alex's life. They performed CPR on Alex's body. In the efforts of trying to perform CPR on Alex's body, they moved the pill container. They put it on the bed. They touched it. When this case was first being investigated, as an overdose. That pill container was sent out to the crime lab to see if it had Alexavier's DNA on it. Why? Because law enforcement was looking to see if this was, in fact, an overdose, just like the defendant said. That's why they sent it out looking for Alexavier's DNA. They were investigating it as an overdose. If you looked at the first search warrants in this case, which was brought up, the first search warrants were looking at child neglect resulting in death because they were looking at it as a potential overdose where drug exposure happened in the home. Is that pointing the finger at this defendant? No, that's keeping an open mind. You heard that the defendant willingly gave over her cell phone. You saw the video. Investigator Williams said, we're going to get a search warrant for your phone. She knew they were going to get a warrant for her phone. It was with that information that she turned it over. But the defense paints it like it was a voluntary, here's my phone, here's my passcode, look at whatever you want. That's not what she did. And don't let them portray it that way to you. Law enforcement did investigator search warrants for her accounts, Google, Facebook. But they also did them for Mr. Pedrin. They were also examining him as a potential suspect. You heard that they did search warrants for her and for Mr. Pedrin. But it was this defendant's words to investigators originally, and this is important. That morning, she said that Alexavier was asleep the entire time that Mr. Pedrin was home. Alexavier was asleep the entire time that Mr. Pedrin was home. Why is that important at that stage of the investigation? Because the autopsy is done on February 13th, and that's where they see all the internal injuries. Based on the internal injuries, they now know that this is a child abuse case, that it's a severe child abuse case. But what the defense doesn't want you to know is that the investigators are relying on her word during this portion of the investigation. Her word is that Alexavier was asleep during that time frame when Mr. Pedrin was home. And so what does that mean? That narrows the suspects. Mr. Pedrin couldn't have committed the child abuse according to her words. And so they have now lost probable cause to get a search warrant for his phone. But they don't tell you that. And so they continue to investigate. They have the internal injuries. They have the forensic interviews of the children. And the forensic interviews of the children, in all of the forensic interviews, not one of the children ever says that Mr. Pedrin does any form of child abuse to any of them. A riot, no child abuse by Derek Pedrin. Brantley, no child abuse by Derek Pedrin. Major, no child abuse by Derek Pedrin. But they all point the finger at this defendant alone. Those children were in two separate homes, and they talk about hitting, kicking, and choking by this defendant. That's magnificent coaching by some power from above that children in different homes can magically say the same thing unless that's what happened. And so now, they are looking at this defendant for child abuse. Because this defendant's own children say she's a child abuser. And then they get the toxicology results. And they have a conversation with Mr. Pedrin. And I want you to think about what Mr. Pedrin says regarding the toxicology results. I buy Xanax. He's admitting that he illegally purchases Xanax. He's admitting that he illegally purchases Xanax for her. And who has the phone? The only phone with a text message that comes back to Xanax. This defendant. Text message to her mother saying, do you want to try a Xanax? What does that message tell you? She has Xanax, she possesses Xanax, and she's willing to give it out to someone else if they want to try it. Now, she's had the benefit of listening to everyone testify. She's had the benefit of seeing that text message and knowing it's going to come into evidence and having to come up with an excuse for it. And how much did you hear that she was prepared? She initially said that she prepped every week since being charged in this case for the moment that she was on the stand. Think about when she was charged with the offense and she got a copy of the criminal complaint. And it mentions the child abuse, and it mentions the Xanax for the first time. She knows about the results. Who's the first person she calls in this world? Mr. Pedrin. What does she say to him? I love you. Repeatedly. I love you. Do you love me? I want to talk to the children. And what does Mr. Pedrin say? He allows her to talk to the children. heard arguments from the defense about the theory of the case. The theory of the case. Investigative Sergeant Rich Amundsen testified that Mr. Pedrin is still a suspect. What do you know about this case? You know he was bringing Xanax into the home. Heck yeah, he's still a suspect. You know he committed child neglect. Heck yeah, he's still a suspect. There's nothing that Investigator Sergeant Amundsen said that is not true. But they want you to believe that because he's a suspect in those things, he's a suspect in the abuse and death. That's not what was said. They were asked if he was still a suspect, and the answer is yes. To neglect, to delivering Xanax to her. And you're asked about a working theory of the case. You heard the theory of the case, not from Investigator Williams, who was removed from the case after doing a few months' work on it, is obviously upset about being removed from the case, and hasn't done any work on it since, but you did hear a complete theory of the case from the investigator that's been on it ever since. Let's talk a little bit about the DNA evidence, because the defense wants to make a big deal about that DNA evidence, right? You didn't test the bag that belongs to this defendant. You didn't test the pill container that belongs to this defendant. It was tested. It was tested for Alexavier's DNA. And then when they went back and watched the body cam, they saw CPR being performed. And then they saw those containers being moved. That's Alexavier's DNA being transferred to those containers. The bag is her bag. Of course it's going to have her DNA on it. What they didn't explain, and what they can explain, because it demonstrates her guilt beyond a reasonable doubt, is that bag coming down and being put on the floor. Is that pill container being emptied out? Is that pill container being used to stage an overdose? And what did that buy this defendant? It bought her time. It bought her time that day because the investigators allegedly looked at the scene and said, this does look like an overdose. But then they started putting the pieces together. They started looking at the evidence, because what they didn't know when they responded to that scene was all the internal injuries that Alexavier had before he was administered those drugs. When you know those injuries and you know how severely this child was abused, when you know that in the context of this bag and a child having to open that container, when you know that the pills were dumped in that bag, you know it's staged. The defense also keeps throwing out overdose, 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 as if that's what the medical examiners said in this case. The practice of medicine involves differential diagnosis. It involves looking at the entirety of the facts in the picture. If you look at just the pills and the toxicology results in this case, it's consistent with overdose. That was the question. But you have to look at it in the context of a beaten and battered child who is then drugged, who is then given the amount that could kill an adult human being. Who is given an amount that's going to result in that child being unconscious and dying within hours. That completely removes Mr. Pedrin. There's only one person in the world who had the ability to administer drugs to that child, this defendant. There's only one person who had the ability to abuse that child without anyone else knowing about it. That's this defendant. There were other children in the home. Mr. Pedrin was there. She said Mr. Pedrin couldn't have done it originally. It was only after being charged at trial that she says, this is what I heard in the bathroom. But you also know that didn't happen because you know how severe those injuries are and you know how symptomatic Alexavier would have been. A fractured rib, a lacerated liver, bleeding into his mesentery. You saw the photographs of all of his injuries. You heard that law enforcement had contact with him and saw none of that. You heard that Laura Lee heard a voice of a child that was okay at 10:30 at night. Dr. Quinton testified that both the injuries and the toxicology in his system were substantial factors to his death. So no, it's not correct that if you rule out toxicology as an overdose, and if you look at just the pill matters, that this isn't a homicide. That is not what Dr. Quinton said. And the other forensic pathologist, the one who didn't write a report, if we're going to criticize law enforcement for not writing a report during a meeting with somebody, what about their forensic pathologist who didn't write a report with all of his findings and conclusions? It was left to me asking questions, only to find out that his opinion is that an adult abused a child, that he would have been symptomatic rather quickly as a result of those injuries, and that with that amount of toxicology of Xanax in his system, he would have been unconscious and dying within a few hours. That was their expert's testimony that he couldn't bother to put in paper despite being paid $12,000. Why, the defense screams. The instructions that you have in front of you say that the state does not have to explain motive. And don't let them put that on the state. That is not the state's responsibility. The state's responsibility is to prove facts and evidence. And the facts and the evidence are that this defendant brutally beat a child and then administered Xanax. There's only one person in the world that could stage that scene, to bring that bag down, to empty the pill container, to put it by the body, to buy more time. Those who have nothing to fear have nothing to hide. Who's the person who's been hiding things and concealing things since the very beginning of this case? Whose testimony wasn't even commented on by the defense? This defendant. If children get something wrong on the stand, they're inconsistent. If children are too consistent, they can't be believed. That's also what was argued in this case. What kind of world do we live in where we can attack a child no matter what they say in a courtroom? It's just never going to be good enough. Because child abuse is a crime that happens behind closed doors, and if it's children that witness it, too bad, so sad. No matter what, they just can't be believed, even when they're that consistent. Those who have nothing to fear have nothing to hide. This defendant has hid a lot. Tell her that you see her. Tell her that you see her for who she is. Tell her that you know what she did to Alexavier. Tell her she's guilty.
Thank you, Mr. Torberson. So, ladies and gentlemen, carefully consider the closing arguments of the attorneys, but arguments and conclusions and opinions are not evidence. Draw your own conclusions from the evidence and decide upon your verdict according to the evidence and upon the instructions given to you by this court. You are to decide this case fairly and impartially, without fear or favor and without passion or prejudice. You are to decide only whether Josie Dikeman is guilty or not guilty of the offenses charged. Any consequence of the verdict are matters for the court alone to decide, and you must not and must not affect your deliberations. No. The following 8 forms of verdict will be submitted to you concerning the charges against Josie Dikeman. In count one reading is, we, the jury, find Josie Dikeman guilty of first-degree intentional homicide as charged in count 1 of the information. Another, the second reading, we, the jury, find Josie Dikeman guilty of first-degree reckless homicide as charged in count 1 of the information. The third reading, we, the jury, find Josie Dikeman guilty of second-degree reckless homicide as charged in count 1 of the information. The fourth reading, we, the jury, find Josie Dikeman not guilty of count 1 of the information. Another reading, or count 2, another reading, we, the jury, find Josie Dikeman guilty of chronic neglect of a child. Consequence is death as charged in count 2 of the information. Another reading is, we, the jury, find that Josie Dikeman not guilty of chronic neglect of a child. Consequence is death as charged in count 2 of the information. Count 3, one reading, we, the jury, find Josie Dikeman guilty of physical abuse of a child, repeated acts causing death as charged in count 3 of the information. If you find Josie Dikeman guilty, you must answer the following questions. Did at least one violation cause the death of the child? Yes or no? To answer yes, you must all agree on the violation that caused death. If you answer no, you should consider the following question. Did at least one violation result in great bodily harm to Alexavier Pedrin? Yes or no? To answer yes, you all must agree on the violation that caused great bodily harm. The final reading, that's on the second page. We, the jury, find Josie Dikeman not guilty of physical abuse of a child, repeated acts causing death as charged in count 3 of the information. I just point that out because it's on a separate page in the verdict you'll be given. It is for you to determine whether Josie Dikeman is guilty or not guilty of each of the offenses charged. You must make a finding as to each count of the information. Each count charges a separate crime. You must consider each one separately. Your verdict for the crime charge is one count must not affect your verdict on any other count. This is a criminal, not a civil case. Therefore, before the jury may return a verdict which may legally be received, the verdict must reach unanimously. In a criminal case, all 12 jurors must agree in order to arrive at a verdict. When you retire to the jury room, select one of your members to preside over your deliberations. The presiding juror's vote is entitled to no greater weight than the vote of any other juror. If you need to communicate with the court while you're deliberating, send a note through the bailiff signed by the presiding juror. To have a complete record of this trial, it's important that you communicate with the court only by written note. If you have questions, the court will talk to the attorneys before answering, so it may take some time. You should continue your deliberations while you wait for an answer. The court will answer any questions in writing or orally here in open court. When you've agreed upon your verdict, have it signed, dated by the person you have selected to preside. After you have reached a verdict, your presiding juror will notify the bailiff that your verdict has been reached. Everyone will return to the courtroom. The verdict will be read into the record in open court. The court may ask each of you if you agree with the verdict. So at this point in time, we're going to swear the officers. No, we're going to we'll do the alternates after we swear the court officers.
Do you swear that you will, to the best of your ability, keep all jurors sworn on this trial together in some private and convenient place until they have reached their verdict or are discharged by the court? And that you will not, before they have rendered their verdict, communicate to any person the state of their deliberations or the verdict they have agreed upon?
All right, at this time, we'll select the alternates. The two numbers, because today is May 14th, 5 and 14. By the way, your names are randomly given different numbers, 1 to 14, so I don't even know what that is. There's two random numbers here. Who are the two alternates? And rather than their names, if we could use initials. 5 and 14. Initials.
NK.
Is there only one NK here? NK? Nobody's NK? Okay. Okay. WM. Okay. So we have the two. So the two alternates, what I'm going to do is have all of you go on out. The two alternates, if you could meet me in my office, we have a couple minutes to do some things, but I want to talk to you for a minute. Oh, thank you. Please leave your instructions there. I will gather them, we'll bring some back, and we'll also bring you the verdicts. Thank you. Okay, everybody may be seated. Some minor detail that just occurred to me is tomorrow we have a different bailiff coming for one of the bailiffs. So we'll have to swear that bailiff in. My question is, we should do that on the record when they get here. Parties can be there, obviously, for the swearing. I would do that at 8:30 tomorrow. Well, as soon as they came up with the jury. That's just we just have we have a different bailiff tomorrow afternoon. So somebody can come up to represent the parties. Not everybody has to be here necessarily, but just so you know. I'll ask them to show up at 8:30, and as soon as they're all here, we'll ask them to hold off, and then once the jurors or the bailiff is sworn, we can start. Does that sound like a way to deal with that, Mr. Torbenson? That just occurred to me that's an issue tomorrow.
Yeah, we can make that work.
Judge.
Okay. Then the other, first of all, was there any problem with how I did the final reading of the jury instructions, Mr. Torbenson?
No.
Mr. Zachar?
Oh,
yeah. My usual practice is not to send any exhibits back. If they ask about an exhibit, I'd probably end up calling you and asking you what you feel about it going back. Give us numbers so we can reach you. I initially start with a call. If we need more of a hearing, we'll bring everybody in. The other thing is we're telling the jurors that they can go to about 5:30 tonight. We will break and have them come back tomorrow morning, as I think I said. I'm not sure I said this, but that's what our intention is, 5:30 to 6, whenever they want to break.
Judge, is your intention that if we get close to 5:30 to come on the record and dismiss them, or are you going to dismiss them without coming back?
I will put it on the record.
Okay.
And so we do need somebody available.
Okay.
Between 5:30 and 6 if they feel like they need that break. If we find out otherwise, we'll let you know. But anything further from the state?
No.
Anything further, Mr. Zachar?
Judge, I do have to put objections to the state's rebuttal on the record here. Once more, the concern is burden shifting when the explicit language is what the defendant didn't explain. and expecting a response or an explanation from Ms. Dikeman's side of the case. Additionally, we're going to object to mischaracterizing when the state indicated that all three children said that Ms. Dikeman abused Alexavier. It's arguable even with two of them, but Araya in particular said nothing of the sort.
Okay. I may change my practice and do, so 160 after, because I think that addresses that issue somewhat, which is when you do 160, you say, rely on the evidence. Now, just so you know, I'm not making any comment about it, but what I'm trying to say is that if there is, because rebuttal happens, no, you can't respond. If there is evidence which is not in the record, that tells the jury, hey, you're supposed to disregard it if it's not there. So I think you have to put the objections on the record, that's clear. But I'll note those objections. I'm not going to do anything at this point with the jury and deliberations. So.
Thank you, Judge.
Just for the record, the forensic video of Araya talked about soap in the mouth, and I would consider that a form of potential abuse, especially from a non-parent doing it. But so she did make that statement during her forensic.
Okay. All right, give us numbers. Like I said, we'll let them deliberate for a while, and hopefully we'll let you know if something happens. Thank you.
Prank calls are fun.
Hey, do you want to write yours?
Dreams. Yeah. I'm always up in the middle of the night, so.
All right, thank you, everyone. Oh, shoot, let me give this to them.
Are these just our copy?
Yeah. Yeah.
Do we stay here?
Stay relatively close and keep calm. I will need you back at 5:30. Yeah, I do. I can't get out of the enclosure here. Yeah.
Well, it's not all gonna fit. That's why I'm
You
gonna
can,
use
yeah.
two threads.
This is the Dikeman trial. The question, there's two questions, or really two requests. It's all right. One is, can we watch the first forensic interviews of Major, Brantley, and Araya? And the second one was, can we watch the welfare check body cam videos? Body cam video, I assume, of
Arnine and
Path.
Path.
there's two of them, right?
There are two.
Yeah, we might have to get where they. So first of all, on the issue of length, just so I understand, if I remember right, Major's first interview was. Let me go back through my notes. Was that 41 minutes? Sound about right?
Accurate.
And they're not asking for the second interview, it's just the first interview. And then for Brantley, the first interview, I did not write that down, but I think it was about
30 minutes.
about 30 minutes, yeah. And then if I remember right, Arise is pretty short, it's about 27 minutes or something. So,
20.
Raya, okay. 20 minutes. And then the videos, the body cam videos, I don't know necessarily how long those were. They were relatively short.
They're short
Sergeant's-
snippets.
Yeah, Sergeant Kernine's was short snippets. The
think-
longer one when he was actually in the home, and then Sergeant Paff's, I think, was 10 to 15 minutes.
My guess is they're talking about the video of Alexavier, of the views of Alexavier, actually. But I really don't know. They just said, I'll read it exactly. Welfare check body cam video. That's all they wrote. We could ask for specific areas. I think the forensic, I think they want to see the whole thing of the forensic interviews. I think the welfare check body cam video, there was a whole bunch of bits and pieces that were shown. We could ask specifically which ones. The other thing is timing. Do they want to do it tonight or do they want to do it tomorrow morning at 8:30? First of all, what's the feeling about them seeing these? The only way they can see it is by coming in the courtroom and watching them again. What's the state's position on it?
I have no objection to them seeing them.
Right. And then the only, other than maybe trying to get a little more detail on the welfare, on the body cam question, the other issue would be to do it tomorrow because obviously that's about it's close to 2 hours worth of video, maybe over 2 hours worth of video. Yeah, that's what I was hoping we would do. Sorry. That's what I was hoping we would do tonight. So this is what I'll tell I have to ask the jury this one question before I bring them back. So why don't you wait here a second? Let's see if we can get a detail on that. I'll come back, then we'll bring the jury in.
Okay.
Maybe seated. So, Kevin did just relay this to me. They didn't write it down, but they want to see on the body cam really three things. One is the officer looking through the window. Is that Cernine?
Yes.
Yeah, Officer Cernine looking through the window. And then the two times, I think an officer, I think it was Cernine, that went in and looked at Alexavier. So they want to see those three bits. That's all Cernine. Everybody's okay with that being seen? All right. So what I'm going to do is bring the jury in, and I'll explain that we will review the forensic interviews. We'll probably do the body cams first and then the forensic interviews, just because I think that's how they came in sequentially. I'm not sure that matters, but and then we'll do it tomorrow morning. I'll ask them to be here at 8:30, and as soon as we can, we'll start up. Before we, again, just a reminder, we'll have to swear our other bailiff because we're switching bailiffs tomorrow morning, so we'll do that tomorrow morning too. So then, if we can make sure we have those clips figured out.
Yeah, if I will identify which ones they are, Judge. I think it's the easiest if I play them from my computer. I'll guarantee they're the same ones.
Right.
I'll save so that we don't have the issues with the buffering and stopping that were happening when I didn't have them saved on a
Hard drive.
Yes, yeah.
And that's fine. Any objection to that?
As long as it's the same clips.
Okay. So, so we'll do that in the morning. I'm going to bring the jury in. We'll tell them, I'll give them ask them not to talk about it, and we'll see them tomorrow morning. And I'll explain what we're deciding right now. Okay. All right. All right, everybody may be seated. I'll just start with this. It's inevitable that everybody keeps on sitting in the same seat no matter what. It's human behavior. Anyway, so we did get your question. We're going to allow you to see these forensic interviews and the clips, which was brought to our attention tomorrow morning, though. So if you can get here at 8:30, we'll start as soon as you're all going to be here. And we'll start with those clips. right off the beginning, and then you can go back to deliberation. Now that you're in deliberation, it's become even more important you not talk to anybody, not to say anything. In fact, as you walk out this door, stop thinking about the case. Like that's possible, but try not to think about the case. Reality is you should deliberate together. You shouldn't do anything. I know it's difficult to do that, but we need you to sort of go through this gymnastics of trying to not think about the case and only come together and talk about it. Also, when you get together tomorrow at 8:30, don't talk about the case at all until 2 reasons. One, you want to see the video. Second one is we also have to swear Terry back in and to become a bailiff in order to have 2 people here as bailiffs. So have a good evening. Try to relax a little bit. We'll see you tomorrow morning. Thank you for your time so much. All right, everybody may have a seat. State, any problem with how I explain that to the jury?
No.
Defense?
Yeah.
Okay. So be here, whatever you need to do to set up, 8:15, 8:20. We'll start as soon as they're ready. I mean, you could come at 8:30 if you think you have it all set up. But the jury tends to really get here at 8:30. So that's why I say, let's say 8:25. Gives us 5 minutes to set up. If you need more time, let us know.
Okay.
Sounds
Okay.
good.
All right. Well, we'll see you tomorrow. Take care, everyone.
Thanks, Judge.
Good night.